Reliance upon the case of Savitri Day will not come to the aid of the petitioner as the judgment is mainly on ex parte opinions of foreigners tribunal. So far as the case of Rahim Ali is concerned, it clearly appears that the relevant observations of a larger bench of the Honorable Supreme Court in the case of Sarvananda Sonwal was not brought to the notice of the Honorable Court, as the observations made would amount to reviving the IMDT, which has been declared to be ultra vires by the larger bench. In view of the aforesaid facts and circumstances, we have the opinion that the impugned order dated so and so does not call for any interference. The petition is dismissed.
We already calculated the item. 38.
My lord, I know, but my money is blocked, my lord, 4.5. I don't know what will be the outcome. My submit will be recorded, my lord.
We have received instruction that
Hmm?
the ground of three
There is-
finding our key.
Only one. No problem. Humble request that my urgency is there, so
Okay.
your lordship will record.
Sri K. Kolita Learned Counsel appearing for the
1 to 5 lots.
OIL has submitted that instructions have been received and he accordingly prays for time to file the affidavit in opposition para. On the other hand, Sri D. Das, Learned Senior Counsel for the petitioners, has expressed urgency as by contending that a major amount of money is being illegally is stuck because of the dispute para. Be that as it may, and in the interest of justice, matter is adjourned to be listed on. Tell us a date, Mr. Das.
No, it's
But
okay.
we send it.
On can we have it on 9th?
No.
9th, can you file before 9th?
Sign
No.
it. No.
Okay.
Give us a firm date. It should not take more time.
14 lots.
On 14th, by which date the affidavit in opposition is required to be filed?
Definitely.
Yes.
With the constable, the other side, I bet my item number 58.
15,
58.
58.
2 weeks time to file
58 perhaps has has been transferred to another bench. Court number 1 is not sitting. You have to go to court bench of Justice A.D. Chaudhary. This is in connection with item numbers, all the orders, 42 onwards.
May I
Yes.
please, Your Lordship, I beg to mention item
Mr.
20.
Chaudhary, yes.
May I please, Your Lordship, I beg to mention item number 17. With the
17,
17.
yes.
With the consent of other side, I hear they have filed a reply to the affidavit filed by us.
Yes.
Some clarification, 1 week time.
Okay. You have informed the other side.
Yes, my lord.
I'm appearing for the petition.
Okay. On a prayer made by Sri V. Chaudhary, Learned, you appear as standing counsel, Mr. Chaudhary?
SSA.
Standing counsel assistant, matter is adjourned by a week to enable him to obtain instructions. Para. List on. Give you a date. We have it on when? 26th,
Yes, my.
next Wednesday?
Yes, my.
Okay. 26, 8. Okay.
Lordship, I beg to mention item 21, Lordship.
Yes.
We are yet to file a reply in this matter, Lordship.
You'll be filing reply.
Yeah, just one, Lordship, just 1 week time to file a reply.
What is your name?
S.J. Soikia.
On the prayer of Sri S. J. Saikia, Learned Counsel for the petitioner, matter is adjourned by 2 weeks to enable filing of rejoinder affidavit. Full stop. List on, we'll have it on 7th of September. You get more than 2 weeks.
Also, there's an interim order, interim.
7th September, interim order passed earlier stands extended till the next date of listing.
Highly obliged.
Please, Your Lordship.
Yes.
With the consent of other side, Lordship, I beg to mention item number 25.
25,
Yes,
yes.
Lordship.
What is
With
it?
the consent, Lordship, I request some time, Lordship.
For you file affidavit?
Yes, sir. Lordship, reply also file, I request some clarification, Lordship.
Okay.
That's why.
On the prayer of Sri S.S. Roy, Learned CGC, matter is adjourned by 2 weeks
Lordship.
to enable him to seek further instructions. Full stop. List on. We'll have it on 2nd of September. Is it okay?
Lordship, let it be.
7th of September,
17th, Lordship.
17th.
Lordship, I will not be there on.
Then say 3 weeks time.
Lordship.
17th of September.
Lordship, obliged.
May I please, Your Lordship, I beg to mention item number 35.
3-5.
Yes.
Yes. What is it?
Lordship, Kindly adjourn for the day. My senior is out of station.
Who is your senior?
AM Khan.
A.M. Khan. What about Mr. Bhuya? He is also there. A prayer for adjournment has been made on behalf of Sri A.M. Khan, learned counsel for the petitioners. Health informed. Have you informed the health department?
No, no.
You have to inform first, don't make a mention.
May I please, Your Lordship?
Health, Mr. Bora? New council is doesn't know. Without informing, do not make a mention.
Lordship.
Is it okay, Mr.
Yes,
Bora?
my lord.
কি কৈছিলো? Learned counsel for the petitioner. Matter is accordingly adjourned to be listed on,
17.
we'll have it on 26th,
Lordship.
26th next week, 26,
Obliged.
May I please-
8.
I beg to mention item number 36, Lordship. In this case, Lordship, I have taken the consent of the other side, Lordship.
Hmm.
Some time, more time is required for filing a affidavit. Can it be on second or?
You are
third
for
of-
NHIDC?
Yes, Lordship.
On the prayer of Sri R.K. Talukdar, Learned Standing Council, NHIDCL, matter is adjourned by 2 weeks,
Lordship.
2 weeks,
Maybe
to
fix on second or third, Lordship.
2 weeks to enable filing of affidavit in opposition, full stop. On request, list on 2/9. Yes, madam.
Item number 18, we are for the petitioner.
18. Yes, what is it?
The main the Arvind council is out of station.
Who's the outing, Green Council? Bideka. Okay, when do you want, madam? After a week. Readings have been exchanged. What is your name?
AJ,
You are not on record.
no,
Miss A, a prayer for adjournment has been made by Miss A Jane, Learned Counsel on behalf of Sri B Deka, who is stated to be out of station, full stop. Para, matter is accordingly adjourned to be listed on 26th of August. 26th, yes.
May I please, Your Lordship? With consent of respondent, I beg to mention item number 32, Lordship, admission matter.
Hmm.
I have filed affidavit in reply, Lordship,
Yes,
raised for 2 weeks, Lordship, time.
you will file.
I will file, Lordship,
Okay.
affidavit in reply.
Your TC Das,
P. Sharma, Lord.
P. Sharma. On the prayer of Sri P. Sharma, Learned Counsel for the petitioner, matter is adjourned by 2 weeks to enable filing of rejoinder affidavit.
Yes, Lordship.
List on 2nd of September,
Obliged, Lordship.
May I-
2/9.
may I please, Your Lordship, with the consent of the petitioner, I beg to mention item number 54 to 56.
54 to 56 perhaps is not before this court. You have to go before Honorable Justice Chaudhary. Yes,
the consent of the other side, I beg to mention item number 34, Lord.
yes,
Conducting counsel, Mr. P. Border is out of station due to medical emergency, Lordship,
okay,
and he is such a 2 weeks, Lordship.
2 weeks. What is your name?
Yes, Oja,
BS?
Oja.
You are not on record. On the, a prayer for adjournment has been made by Miss B.S. Oja, Learned Counsel on behalf of Sri P. Bordoloi, who is stated to have some medical emergency. Para. Matter is accordingly adjourned to be listed, adjourned, and on request, the same is to be listed on 2nd of September. 2/9.
May it be your Lordship, item number 37, Lordship, that transport is filed on affidavit today, that may be called from
Yes, please.
DP office.
Your Lordship, I beg to mention item number 23.
23.
23.
Yes.
File,
I am for the petitioner, Lordship.
23. What is your prayer, madam?
instruction given in
You are for a PDCL. You'd like to file affidavit? Yes, we'll give some time. How much time? 2 weeks time, okay.
Earlier interim order may continue.
Okay, a prayer for adjournment has been made on behalf of the APDCL to enable filing of affidavit in opposition. Full stop. Para, Sri A. Sharma, Learned Counsel for the petitioner, has however informed that there is an interim order which is required to be extended. Para. Matter accordingly stands adjourned to be listed on 7th of September to enable filing of affidavit in opposition. Para. Interim order passed earlier stands extended till the next date of listing. Yes.
Wait, please, your lordship. My lord, the order of this honorable high court is at page, my lord, 11. And the relevant para is at page, my lord, 14, para 6, my lord.
Page 16.
Page 14 is the, my lord, and para 6 is the relevant, my lord. Order. May I read, my lord?
Yes.
Para 16, it is under such circumstances, this court therefore dispose of the instant writ petition, thereby directing the respondent authorities, more particularly the respondent number 3, 4, and 9 to verify the entitlement of the petitioner on the basis of the work order which were issued in favor of the petitioner, and as to whether the petitioner had completed the work in question, and thereupon, after verification, if it is found that the petitioner is entitled to any amount, the same should be paid to the petitioner in terms of the judgment of the full bench of this court in the case of Tamsher Ali.
Yes.
The said verification be completed within a period of 1 month from the date of certified copy of the instance order is served upon the respondent number 2, and the payment thereof be made in terms of the judgment rendered in the case of Tamsher Ali. My lord, at page 15, my lord, I have communicated, my lord, on 10/12/2025, my lord.
Not done.
Not done, my lord.
Verification not done.
No, no. No. And I also, my lord, furnish the copy to respondent
Part
number.
3 and Sarkar learned. But this direction was to whom?
My lord, especially respondent number 2, my lord.
Why have we made the other respondents parties?
Because, my lord, verify the entitlement of the petitioner by the respondent authority, my lord, authorities.
Oh,
And more particularly, my lord, 3, 4, and 9.
okay. How 3 and Sarkar learned counsel for the petitioner who by means of this application has alleged willful and deliberate disobedience of the judgment and order dated of the don't say judgment of the order dated 28/11/2025 passed in so and so. The learned counsel has also drawn the attention of this court to the representations and reminders requesting for compliance of the order in question. Full stop para. That notice we issued, returnable on there is Adik Manor. 19th, returnable on 21st holiday. On 23rd, on 18th of September. 18th of September 2026. Steps by speed proceeded 2 days.
Up like that.
May I please, your lordship? Regarding the non-compliance of order dated 8/9/2025, the operative part is para 19 on page 31, lordship. The direction to make payment, which is an admitted position, lordship.
Page
Page
31.
31, paragraph 19. And the action was to make payment within a period of 6 months from the date of receipt of certified copy. On 30/10/2025, we have submitted the certified copy before the deputy commissioner.
This payment are on what head?
For supply of stationary materials for election, panchayat elections, lordship.
For?
Panchayat elections. Stationaries and printing materials, lordship. All amount due are the admitted position, lordship. We have
For
certified
Dr. E to D learned counsel for the petitioner who by means of this application has alleged willful and deliberate disobedience of the order dated 8/9 8/9/25 passed in 465. বাকিখানে সব একই, okay? Take steps within 2 days. By speed post ready. Representation reminders লিখে দিবে, okay? Okay,
Lordship, item 3 to 6 are same.
okay.
The WPT
The
number
order is the same.
Order-
Date of
common
the
order.
order same.
Yes,
WPC to লিখো ওখানে। Check করে দেব।
much obliged.
Take steps within 2 days. Speed
Right.
post ready.
Yes, please.
Mr. Sharma?
This contemplation is for non-compliance of order dated 18/6/25 at page 23. 11th part is at paragraph 7, page 25.
18/6/25.
25, paragraph
Where is the relevant paragraph?
7,
Page?
25.
Okay. Same, huh? P. Sharma. Order to file above. WPC file above. But it was, direction was given to all the respondents.
Order.
Okay. Speed post 2 days. Take steps. Where are your representation? Have you given representation?
I have submitted 3 represent page 27.
Okay. Take it.
All right.
May it please the Lordship. I have refiled this case. Earlier I had filed this and there was an issue regarding the jurisdiction. The issue herein is basically the jurisdiction of the Jila Porifat to collect tolls. Whether, because this is the Gaon Panchayat is coming up before the Lordship with a prayer that if,
Oh, we remember, 2 of
if-
the members had come.
if, yes.
Yes,
My,
now the panchayat has come.
yes. And my case is if the market is having a value of less than 5 lakhs,
Hmm.
therefore, then the toll collection would rest with the Gaon Panchayat level. Here is a market where we have stated that this is a market.
Yes, what do you say?
Five
My
lakhs.
lord, this was very temporary, my lord. Now, my lord, already Lordship is aware that we have already taken the decision, my lord. In very 1-2 days, my lord, it will go to the district and NIT will.
Are you aware of this
No,
development?
Lordship. The
In fact-
NIT would be a regular process of settlement. But the NIT process will also take some time. 45 days, they have to give a time as per the act itself. And then thereafter settlement. During this interim period, who is going to collect the fees or the tolls? My understanding of the law as well as the executive order says any market where the value is below 5 lakhs, Gaon Panchayat, within 10, Anchalik Panchayat, and beyond that is Jila Porifat. This is a market where the amounts have not even reached more than 1 lakh in all the preceding years. So therefore, essentially, the toll collection had to be rested with the Gaon Panchayat.
Why
and
have
not
you
with the Jila
made this
Porifat.
alternative arrangement? Why not by the Gaon Panchayat? The switching over is another matter. But for the temporary collection also, when there is a competent authority having jurisdiction, why have you not given the or taken another decision to get it collected by somebody else?
Here, the peon of the Jila Porifat is collecting as per the order, the impune order. But if you're page 62,
That can, my lord.
Hmm?
Because only collecting, not settled.
No.
settlement is a direct. We are talking about direct management laws.
Where is the,
If a lawsuit will come to the Panchayat Act,
yes,
page 106, if the lawsuit is holding this book lawsuit.
yes. No, give us the section.
105.
105, section 105 of the Panchayat Act.
Yes. Settlement of hearts by
Yes,
Anchalik
lawsuit.
Panchayat.
So 105 subsection 1, if I just read lawsuit,
Yes.
the all hearts within the territorial jurisdiction of the Gaon Panchayat, Anchalik Panchayat or Jila Porifat shall be settled in a manner as may be prescribed for a period coinciding with and not exceeding 1 Panchayat
Mr.
year.
Doctor,
My lord.
those matters have stopped now, those disqualification.
My lord.
There are many matters of disqualification of having more than 2 children.
Yes, yes, my
Now those matters are not coming. Why?
my
No,
lord.
we had a flag here.
That's fine.
So we thought that it would be something important. Then we remembered. There's a series of matters, every day 2, 3.
My lord,
And one of the main contenders, fighters were Mr. Mohanta.
Some of them are still pending. Still pending, my lord.
Pendency is another thing, motion.
Motion.
Also, my lord, so coming
Yeah,
in bench
Mr. Mohanta is more interested in motion.
It's coming in bench 5.
So remove the flag.
Probably temporarily, Lordship can remove it now.
So all are qualified now. We come to 105.
Yes,
Flag will be-
1051. 1051 basically speaks of that there has to be annual settlement by
Now
way of
that
a
is,
regular.
where is the powers?
Yes, Lordship will come to 5.
Hmm.
Subsection 5. Failure to settle any hut for want of adequate value. The concerned Gao Panchayat, Anchalik Panchayat, and Zila Porikhod, as may be decided by the higher body, may be entrusted with the direct management.
Now that
of
we have
the-
seen the value
Yes, value Lordship will find.
in the rules.
No, 7.
7. Next page.
Next page. 7, Roman 1. Notwithstanding anything in the law for the time being enforced, the state government shall transfer such government huts which has settlement value of less than 5 lakhs in a year to the Gao Panchayat within the jurisdiction of which hut is situated. So there is a transfer, there is a conferment of that market upon the Gao Panchayat if it is of a value of 5 lakhs.
You are reading 105?
105, subsection 7, Roman 1.
This book does not have 7.
I think pre-amended.
That was pre-amended.
Pre-amended also.
7, 9. I will be serious.
105, subsection 7,
7 has
Roman.
been inserted when?
It's 2025. That was also 25, but after that, my lord, publication, that was amended again.
My book is 2025 July, your lordship.
This is also 25. This was
Publication-
purchased in March 25.
This is 5th edition, July 2025. I think it has come there, lordship.
Okay. 7. Let us make a mark, otherwise in some cases that be difficult.
Yes.
7. Yes, 7, which one?
7, Roman 1. It gives the classifications, the sub-classification. Roman 1 is regarding Gao Panchayat.
Okay. Third, Sri A. Sharma, learned counsel for the petitioners who are aggrieved by an order dated 1/7/2026 issued by the in charge CEO, Darang Jila Parishad, whereby an individual who is the peon of the Darang Jila Parishad has been authorized to collect tolls from the Amba Chowk cattle market on behalf of the office with effect from 1/7/2026. Full stop. The learned counsel at the outset has submitted that the challenge was initially made by 2 members of the panchayat, and the said writ petition was, however, withdrawn
Withdrawn, lordship,
Withdrawn.
with liberty.
with a liberty to approach through the appropriate person, and accordingly, the present petition has been filed. Full stop. He has drawn the attention of this court to section 105 of the Assam Panchayat Act 1994, which deals with settlement of huts by the Ansalik Panchayats. Full stop. Specific attention of this court has been drawn to the to the provisions of 105 within bracket 5 and 105 within bracket 7. Full stop. He has submitted that the annual value of the market is less than 2 lakhs.
Less than 5 lakhs. Because
No,
that
here,
is-
in this your case, what is
in
the
my
value?
case, I have given the figures 94
It is less than a lakh.
less than a lakh,
and-
94,000,
and therefore,
84,000.
The Gao Panchayat would have the jurisdiction to would have a role under 1055. Full stop. Para. On the other hand, comma, 3, Dr. the learned standing council PNRD has submitted that there is a process for switching over from offline mode to online mode, and therefore the present arrangement is a temporary one. Full stop. Para. Be that as it may, let notice be issued. A temporary one. He further submits that the process has attained, process is almost over, and fresh NIT would be issued by switching over, but we issued by following, issued by following the new mode, MOD. Para? Be that as it may, let notice be issued, returnable on returnable on 14th of September 2026. Sri Datta, the learned standing counsel, accepts notice on behalf of respondent numbers 1, 2,
1, 2, 3, 4, and 5.
5.
Six.
Not 5. Oh, yeah, 5 also. Okay, 5. District Commissioner. Okay, Bukolial. That's 6 District Commissioner, extra copies. Para. Sri Sharma, the learned counsel, for the petitioner prays for an interim order, which however is resisted by Sri Datta, the learned standing counsel, who has contended that the arrangement is a temporary one, which would come to an end immediately on adopting the new process. Full stop. Para. Be that as it may, comma, since the arrangement appears to be in clear violation of the statutory mandate, comma, the impugned order dated 1/7/2026 is suspended till the next returnable date. Full stop. Suspension of the same, however, would not come into the way for switching over to the new mode, to the new process under the new process, new mode. Full stop.
And in
Madam,
the, and in
may-
this,
may I small submit on that point, madam. As per the act, my lord, government has the power, my lord, to transfer. They have not filed any representation before government, my lord. Because the act, my lord, is very clear. Government has the power to, my lord, in 10571, no representation has been filed before government. my lord.
it's not required as per the executive
Okay,
order,
okay.
which is also a part of the record,
Okay.
which says any dispute between for settlement is to be handled.
The collection of the tolls has to be done strictly in accordance with law.
Fine.
Yes, you can take this back.
Yes,
Accordance to law by the Gao Panchayat lordship, because the Gao Panchayat has
Strictly in
the.
accordance with law, we have said.
Yes, lord.
We have stated that.
Yes, lord.
We
Because
cannot
there,
stop
now
the
there will be a
collection.
gap. In this gap, who will collect the money?
No, we have not stopped that.
Yes.
Strictly accordance with law, they will
In
be
accordance
collected.
with law.
You take this, আমার এখানে এখন কি নিবা, হ্যাঁ?
Oblige.
Item 9, yes.
May I please, the lordship?
Mr. Borbia.
Yes, my lord. This petitioner earlier also approached this honorable court, and this honorable court passed one judgment, my lord, page 38 onwards. And relevant portion, page 40, my lord, paragraph 6. Here, my lord, according to petitioner, he supplied raw materials for 20 lakhs, my lord. And after field verification, it was valued, my lord, 15 lakhs something. Accordingly, this honorable court directed whether it may be 20 or 15 lakhs, that should be paid, my lord, without delay, and time is also given 6 months. Now, my lord, they have paid only rupees 9 lakhs something, and this order is page 50. Here they only, my lord, past bill as regards bill number 19, 94, 95, 97, 98. Only selectively they, my lord, payment made. However, there are, my lord, total 11 bills were submitted, and those bills were
Mr.
duly.
Borbia, you are trying to reopen the issue. Issue has already been settled.
Yes, my lord. Now, my lord,
Whether it is 20 or 15, it has been verified and paid.
Yes,
Now
my
they
lord.
have verified, found to be the amount to be 9,47,000 and paid.
No, my lord, lordship kindly.
If you expect more, or if you think that something has been left out, you have to approach the appropriate forum.
Lordship kindly will look page 34, my lord.
3-4.
34.
Yes.
Here bills number are given, my lord, bill number 89 to, my lord, 99, 11 bills. Here they only paid this bill, my lord. But this is a, my lord, road, my lord. It was constructed road, my lord, and different items were supplied, my lord. And this honorable court direct, and their own report earlier also, page 37, it is 15 lakhs, my lord.
These are of 2019. Where is the judgment? Let us see the judgment.
Yes, my lord.
Page
Page 40, my lord,
40.
relevant portion 40, paragraph 6. This court further finds it relevant to observe that the petitioner claimed that he supplied materials of value rupees 20 lakhs and the verification report enclosed as Annexure 7 shows that the entitlement of petitioner is 15 lakhs 34,748. This court in exercise.
Now this 15 lakhs is also not paid.
Yes, my lord.
9 lakhs 47.
Only one
Yes, Mr. Doctor.
My lord, the earlier order says my verify and pay, my lord.
No, the verification court had taken into consideration a verification report.
My lord.
15, 34, 748 was the verification report, whereas he had claimed 20 lakhs. So now the amount which has been paid to him as contended by the learned counsel is 9,47,000.
My lord. Thereafter, my lord, taking into consideration of above, this court directs, this is the direction, my lord. The respondent authority is to verify the entitlement of the petitioner, and the respondent authority, if upon verification finds that the petitioner is entitled to any amount, the same be paid to the petitioner. Thereafter, lordship, one contempt petition has been filed, my lord, and after in contempt petition was direction was there to re-verify again and complete the verification process. And thereafter, this.
Then you have to approach the civil court.
My lord,
We cannot reopen this.
lordship,
This is
kindly,
If you think that you are entitled to more than 947, you have to establish your claim.
lordship, page 47, my lord, last photograph of the work, lordship.
We know that, but this has to be proved in accordance with law. Now this payment of 947 has been done after a verification. The verification may be done perfunctorily, we do not know. That may be your claim. That has not been done in accordance with law. But
But to this effect, my lord, they have also not, my lord, written any order is also passed. That it is found so and so, my lord. All reports has come in my favor, my lord.
No, my lord.
by which order the payment has been made?
Page 50, my lord.
50, yes, let us see.
It is so nicely done, my lord, work, and I am just supplier. It is still work is intact, my lord, as per recent photographs and report also, my lord. After so many years.
Okay, heard 3 AM Borbia, learned counsel for the petitioner. Full stop, as per the facts projected, comma. The petitioner had earlier approached this court by filing WPC 5560/2021. Full stop. The petition was pertaining to a claim for certain supplies. Full stop. It is the specific case of the petitioner that while the entitlement was rupees 20 lakh, comma, the verification made by the authorities had stated that the amount was 15,34,748. Full stop. This court wide an order dated 2/8/2023 had disposed of the said writ petition by directing a verification exercise to be made and thereafter pay the amount which is admissible. Para? Pursuant thereto. Thereafter, a contempt petition was also filed. Full stop. Be that as it may, comma, finally, a verification exercise has been made and an amount of rupees 9,47,000 has been paid to the petitioner. Full stop. Para, the learned counsel has contended that while making the said payment wide letter dated 19/7/2025,
Yes, ma'am.
comma, certain bills are apparently left out,
Ma'am.
which are left out. For so he accordingly submits that the verification exercise as directed by this court has not been properly done. Para. On the other hand, comma, Sri Dr. the learned standing counsel PNRD has submitted that the earlier direction of this court has been duly complied and the amount released after the verification exercise was carried out. Puts the para. Be that as it may, in view of the submission, that's apparently certain bills were left out in the verification exercise, let notice be issued, returnable on 18th of September 2026. Sri Datta, the Learned Standing Council accepts notice on behalf of respondent 1, 2,
1, 2, 4, and 5.
4, and 5. Bokolial, 3 extra copies. Get the instructions.
11 bills for 11 different items. Without one item, another item is meaningless. It is a composite one. It is a construction work. Therefore, they cannot selectively one item is given another. Totally different 11 items. Deep your
May I be the Lordship? Lordship, we seek permission to withdraw this petition, Lordship, with a liberty to file a
Mr. Dhar,
My lord.
you have done something
No, my lord.
in the morning.
Matter is not maintainable, man. I
Huh?
can just
Threatened.
so no, I didn't threaten my lord, but they got threatened my lord. Maybe they
What
have done
threatened?
No, actually,
Subtle threatening.
some new facts has to be brought on record. This is my instruction, Lordship. Therefore, I pray that Lordship may be allowed to, Lordship may be pleased to allow us to file a fresh Lordship.
Okay, what is your name?
P. Das, Lordship.
Repeat the Learned Council for the petitioner at the outset has submitted that he may be given, Learned Council for petitioners has submitted that he may be given, he may be allowed to withdraw this petition with a liberty to present it afresh. Footstop. Para. Sri Ardhar. Learned
Retainer council, ED.
Learned Retainer Council for the ED has submitted that the petition otherwise is not maintainable. First para, be that as it may, comma, the petition is dismissed on a draft with liberty as prayed for.
May I please, my lord? My lord, may kindly pass over the matter for the time being. Lordship,
What is the matter?
Lordship, it's an illegal termination matter from service.
As what?
Lordship, he was serving as a sub-editor in a publishing house.
Publishing house.
Yes, Lordship. It's called
How do you come to a writ court?
Lordship, there was an award passed by the Learned Labor Code, Lordship. We are challenging that under Article 227, Lordship.
We have come against an award of the Labor Code.
Yes, Lordship.
Termination has been upheld by the award.
Yes, Lordship.
Let us see the award.
Lordship, I don't have the file, Lordship. The
Bring
appointed legal aid counsel is in legs in court number 2, Lordship. But it's the last annexed, Lordship. Lordship, it starts from page number 62.
Resurrection. Resurrection. Okay, after a while.
Yes, Lordship.
May it please your lordship. My lord, in this case, my lord, the petitioner, my lord, he was settled with the fisheries.
Yes,
my
Mr.
lord.
Sharma, where is he?
Chief, he could not come to court due to waterlogging.
Waterlogging. Yes.
My lord.
Will you take notice on his behalf?
Yes.
Is there any interim prayer?
Yes, my lord, because my lord, now my lord, my settlement has been cancelled, my lord. And this cancellation was basically on the account, my lord. My lord, what has happened, my lord, in the pendency of my case, my lord, there was a civil judgment and order of 2005 for which by and title execution was also filed subsequent thereto, my lord. And the major portion, my lord, around 13.76 hectare out of 30 hectare water covered area has been taken possession, my lord. So I make a representation before the
But
authority.
cancellation, how do you stay a cancellation?
But subsequently, they have also issued the NIT, my lord, against the same work, my lord. And they have also mentioned, my lord, in that my lord, tender, my lord, of the same area which was earlier there, my lord, in the original.
This new NIT is dated what?
New NIT is dated, my lord, 13/7/26, my lord.
13/7.
Yes, my lord.
More than a month has passed.
31/7, my lord.
15 days.
Yes, my lord. 15 days, my lord.
20 days.
Yes, my lord. But my lord.
What is the stage now?
Stage, my lord, they have only cancelled, my lord. We have make a representation before.
No, stage of the new tender.
No, my lord, it is, my lord, as per that.
Last date?
Last date, my lord, it will 24th, my lord. And it will be open on 26th, my lord.
Difficult, Mr.
But my lord,
I heard 3G Alam Learned Counsel for the petitioner who, by means of this petition, has challenged an order of termination of the settlement of the Rani Meghna bill
yes, my lord.
in Sribhumi,
Yes, ma'am.
which was settled with him for a period of 7 years.
Yes, ma'am.
Full stop. He has submitted that the said termination has been done on without taking into consideration the relevant factors.
Yes, my lord.
He has also informed that in the meantime, a fresh tender notice dated 31/7/2026 has been initiated.
Yes, ma'am.
Para, that notice be issued. Returnable on 14th of September 2026. Yes, what is your name?
Kedas.
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 Kedas. Sri Kedas Learned Counsel, appearing on instruction of Sri P. Sharma, Standing Counsel, AFDC. Accepts notice on behalf of all the respondents.
Not like a performer, my lord.
Not this,
Yes,
8, I
okay.
think.
7 and 8. 7 and 8.
For respondent numbers 1 to 6, whereas Bukolian 7 and 8. Extra copies. Sri Alam, the Learned Counsel, pays for an interim order. Full stop, para. He has submitted, para, not para, interim order. He has submitted that if new settlement is made pursuant to the tender notice dated 31/7/2026, comma, the subject matter of the writ petition would become infructuous. Mr. Para, considering the same, comma, while this court is not inclined to stay the new tender process initiated by the order dated 31/7/2026, comma, it is directed that till the returnable date, comma, no orders of settlement be issued, though issued full stop. However, there is no restraint on the process which has been initiated.
My lord. Oblige, my lord.
May I please, Lordship, I may be allowed to appear on behalf of Mr. A.M. Ahmed, Lordship. Lordship, we are aggrieved by the impugn order, the communication page 47, Lordship. More particularly, second last paragraph, Lordship. Page 47, Lordship. And then, record of time.
Our bench 4 and 5
Four.
Some issue was raised on the last occasion, whether it's 4 or 5.
It was a matter,
Four
was
matter,
listed in court number 6, Lordship.
Okay.
Wrongly listed.
Wrongly listed.
Okay, it should be 4 actually.
Yes.
Yes.
Settlement is a fourth.
Okay, what is it?
Lordship, it's, my lord, that notification, my lord, for upgradation.
For?
For upgradation of the tender process, that kind of matter, my lord.
Okay,
Page 47 is the impugn communication, Lordship. We are agreed that Jila Parishad CEO informed the BDO to make temporary settlement until further order.
As per government orders instruction.
okay, it will be done in accordance with law. Yesterday I had passed a detailed order, I think.
There may be direct management till Lordship.
Yes,
Yes, Lordship.
no, we had heard a matter in details.
Lordship.
Even a temporary settlement can be done, but there has to be some process.
Then some process. Lordship.
Otherwise, you run it directly by the department, 105.
Lordship.
Read it, rule 47.
1055.
5, read it, read it rule
Direct,
47.
direct.
Direct.
Okay. What is rule 47?
Rule 47 is the process for settlement.
Tender process and
And that is a violation, that means. Okay, Hard.
This order is not saying, my lord, that without tender or something like that to settlement.
okay. But how do you know? Have you made a statement that it has been done without any tender?
Lordship.
Where is the impugned order?
Impugn page 47, Lordship. Page
47.
47, second last paragraph.
Without tender, it will be given.
Hmm?
Or not.
Page 47, second last paragraph, Lordship. We are agreed with that.
In the meantime,
Lordship.
maybe given from. But how is it given as nothing has been
Because, my
specified?
lord, actually, the dispute is, my lord, that Pargat is within the jurisdiction
Of two Anchalics.
panchayats.
Lordship.
That is the process, my lord. Until unless the final settlement, it's alternatively they have to settle. That is why.
But where is your averment or case made out that this settlement has been done without following any tender process?
Lordship. Para
Your
12 page.
case is slightly different.
Lordship. Lordship. Para 12 paragraph, page 12, paragraph 12, Lordship.
12.
Lordship.
Okay.
And paragraph 8 also, Lordship. Page 10, paragraph 8 also, Lordship.
This 10 paragraph 8.
It's not saying, my lord.
Lordship. Paragraph
It's
8.
not saying without tender.
Paragraph 8, Lordship.
We have not stated anything.
They have filed only on presumption, my lord.
You have to have a specific statement.
Lordship.
Have an additional affidavit filed. Okay.
Lordship.
Heard Sri M.K. Hussain.
Or lordship can dispose it of saying, my lord, without tender, that cannot be settled.
But we do not even know whether it was done by settler. Sri M.K. Hussain at the outset submitted that an additional affidavit is required to be filed to specifically aver that the impugned process was not preceded by any valid, the impugned settlement was not preceded by any valid process. Let such affidavit be filed. Let this matter be listed immediately on filing of such additional affidavit. You file it within a day or two, next week it will be taken.
Okay.
61.
My lord, tender was floated by the Divigod Medical College, my lord, for cleaning, sanitation, a disinfection service, my lord, for a period of 1 year. There is eligibility criteria.
What kind of
This is cleaning, sanitation, and disinfection service in the medical college, my lord. So this is eligibility criteria.
do you know what is BDM? We thought BDM was something else. Have you heard of BDM? Mr. Mahanta knows what is BDM. Very popular. BD Mahajan.
Very well.
What is it? You don't know?
Advocates.
No. You are a cricketer and you do not know BDM.
Huh?
You don't know BDM bets.
Video bit I don't know.
Oh my God. BDM and RKM were the only bets available during our days. Mr. Mohanta, am I correct? BDM better quality than RKM. Only two quality.
Yes, it's a good name, otherwise.
We thought you were
My
a
lord.
cricketer.
My lord.
BDM Enterprise. So what is it?
So, my lord, there is a eligibility criteria. Lordship will find page number 44.
There
Eligibility.
was a tender process
Yes.
by 16/7/26.
Yes, my lord.
You had participated.
Yes.
What happened thereafter?
And respondent number 6, he has also participated.
Yes.
In page number 44, Lordship will find there is a eligibility criteria that he
Clause
should,
two.
yes,
Clause 2.
2 years experience in the cleaning sanitation, annual turnover. My lord, this particular respondent number 6, he has no experience for even 1 day. He provides security services, my lord. And they have made him L1 and ultimately they have allowed him to work, my lord. He does
work.
what has happened? What they have done now, I was on extension because I'm working from 2023. Now they've asked him, you start work. So he said that please give us the work order. Work order is not given to us, but he's working. There's no doubt about it. From 23rd, he's working, my lord. So today my humble submission is, my lord, since this period is only 1 year, my lord, Lordship may kindly
You
direct
get the
the
instructions.
instruction and that only instruction, my lord. Records, and a bit short date, my lord.
Okay.
If necessary, my lord, Lordship asked me to take a justice service, my lord, within 10 days, Lordship, I'll just take the steps today itself. Because I'm not going to pray for interim order today, my lord. There's no point.
Heard 3M, not learned senior counsel, assisted by Miss Deka, J. Deka,
DL Dekha, your lord.
DN Deka, sorry.
My
DN
lord,
Deka.
not only Lordships, nobody can remember something, but every court it happens, my lord. DL, everybody.
Is it so difficult?
She said because of her name, I don't know why.
What is your full name? We'll remember.
Preeti Lekha Dekha.
DL, okay. Pretty Lekha Deka, okay.
What I when I
Full stop. As per the facts projected, comma, pursuant to a tender notice dated 16/7/2026, the petitioner, along with others, had participated in the same, full stop. The work
Coordinated.
was pertaining to cleaning, sanitation, and disinfection services
Yes.
of the Assam Medical College Hospital, Dibrugarh, full stop. It is the specific contention that though the respondent number 6 has been selected, has been held to be technically qualified and thereafter selected, comma, the said respondent number 6 was only a security service provider and do not have the eligibility criteria of 2 years experience in the nature of the job, full stop. The learned senior counsel has, however, submitted that the work has already been handed over to the respondent number 6, which, however, is for a period of 1 year.
Yes.
Full stop. Para. Let notice be issued, returnable on. We'll make a short notice.
Short.
Today is 19th.
Yes, my lord.
We'll have it on 11th. 11th is okay. Can you do it?
Little early possible.
Little early that earlier week.
I'll take steps.
Fourth is a holiday. First is a holiday.
First is a holiday.
7th.
7th, my lord.
7th, madam.
Yes.
7th of September. Miss D. Bora, learned standing counsel, health and family welfare, for 1, 2, 3, 4, and 5 extra copies. Last steps be taken for service of notice on 6 by speed post with AD on request for Dusty Wala to be routed next date. Then affidavit. You have to file an affidavit before the next
Yes,
date.
yes. I'll do it, my
Okay.
lord. I'll do it.
The
I can take speed post, my lord.
speed post
Yes.
is the normal
Yeah.
and Dusty also.
Yes, yes.
Okay, and the prayer for interim order. No. The senior counsel for the petitioner has prayed for an interim order by submitting that such settlement with the respondent number 6 is prima facie bad in law, in as much as the respondent number 6 did not fulfill the essential requirement to be technically responsive, full stop. Since the matter is of immense importance, comma, while this court is not inclined to pass a blanket interim order, comma, it is provided that on the next date, comma, the interim prayer would be considered upon receipt of the instructions by the learned standing council.
Obliged.
Are you in a position to do the work?
We'll try, we'll try.
Now, if we are inclined to, suppose you make out a case that he has not fulfilled.
Ready, I'm ready, everything. I'm doing since 23, I'm doing the same work. Last 3 years I'm doing, my lord, and I'm fully eligible. Obliged.
Okay. Yes, madam.
Lordship, in this matter, we are challenging the impugned award passed by the Learned Labour Court dated 29/1/2026.
But Labour Court has come to a conclusion that your grievances have been redressed.
Lordship will kindly consider two aspects. The first aspect is there were 3 grievances raised in the complaint. The first 2 grievances have been addressed. But so far as the last grievance is concerned, the first grievance is concerned, reinstatement of workman in service with full back wages and consequential right and benefit of service. So the
But you were given the termination benefits. Thereafter, where is the question of
Lordship, the
reinstatement?
back wages have been paid. The 1 month salary for April, that has been paid. But so far as reinstatement is concerned, the respondent had merely made a proposal to me to rejoin service. But in that particular letter, the direction was that my duties were being curtailed. So that did not amount to a reinstatement. Certain conditions were being imposed on me. And that is the reason why I did not join in that particular post, because that amounted to a demotion.
Will that amount to
Lordship kindly sees,
termination?
if your lordship kindly sees page number 47.
Okay, heard Dr. P. Agarwal, learned counsel for the
Legal counsel.
petitioner, learned legal aid counsel for the petitioner, who has put to challenge an award dated
29/1.
29/1/2026, passed by the learned labor court, Gauhati,
Yes, lordship.
full stop, by the said award, comma, the termination of the petitioner has been upheld.
Yes, lordship.
Para. Let rule be issued, returnable on 23rd of September. Call for the records. Let notice be issued to the sole respondent by speed post with AD. Steps within 2 days.
Lordship. Deeply obliged.
Pertaining to 60, what are these?
Contextual being valid. For number 6 and 7, I have received instruction, my lord, and if state has already filed their affidavit. But here, my lord, affidavit is required from 8, my lord, respondent number 8.
You present 8.
Yes, my instruction and in the seeding of the state is same, my lord. Because of audit observation, we could not release the fund, my lord. And then C is for 8, my lord.
So what can be done? We take up for disposal today. Okay. What is your name, madam?
Lordship, A.K. Chope, appearing on behalf of Mr. M. Biswas.
AK, you give your name, okay? Heard Miss Swenson, learned counsel appearing on instruction of Sri M. Biswas for the petitioner. Full stop. Also heard Miss R. Deka, learned standing counsel, Water Resource Department, who has filed affidavit. Full stop. Miss A. Gan, learned CGC, you have also filed affidavit,
Instruction, my lord.
has submitted that instructions have been received, which are in tune with the stand taken by the department. Full stop. Both the learned counsel for the department and CGC have however submitted that due to certain audit objection, comma, the the amount has been withheld. Full stop. Shri R.K. Talukdar, Learned Standing Council. Accountant General, prays for time to take instructions and file affidavit. Full stop. Para. Matter is accordingly adjourned. To be listed on, we'll have it on 18th of September. You get enough time to file the affidavit. I think one affidavit will do, madam, or are these connected?
I'll also file affidavit.
Hold on, okay.
Yes, madam, one affidavit is.
Parties are the same or different parties? I think you need to file different affidavit, Mr. Talukdar. Only the structural change will be the other stand, principally stand will be the same. So last week, last week, क्या बोला? Last. So full stop. Matter is accordingly adjourned to be listed on 18 for exchange of further affidavits. AG wants to file an affidavit. If you want, we can record your name, Mr. Vishal.
No, it's okay. It's okay.
This matter, the department sorts of more time because they are taking the matter of the DC because of that is pending before the deputy commissioner adoption. Because what has happened, since he was not getting the NOC from the Polasbury Municipal Report,
Now
he
you-
submitted a proposal to another location. We inquired into the location, there was objection, and the objection is placed before DC. And DC had to take up or whether under Rule 289.
Yes, Madam DC.
No,
You resolve it. We have been passing orders after orders.
sir.
Every time Mr. Gogo will push it to Ms. Madam Das.
you give a new allotment or you give me a return back
refund
my
the
money.
money.
72 lakhs.
There was a Polasbury pass a resolution after the issuance of the NIT not to issue any license. Even there was
No,
a
that is okay. He is not insisting on the license. He is insisting.
Yes, even you.
If you have a problem, refund the amount.
But since he is allowed to shift to different place, we have to inquire.
Now
different-
inquiry has been going on, but
Inquiry has been
some
going on.
new person come always, my lord, they are imposing some new condition. So let
Heard
The-
Sri T.J.
the-
Mohanto, Learned Senior Counsel, assisted by Sri A. Burua, for the petitioner. Also perused the earlier orders passed in this proceeding. Full stop. Para. Sri R. Gogoi, Learned Standing Counsel, Excise Department has submitted that the matter has been inquired by the District Commissioner.
And inquired by the Excise Authority, and thereby some complaints were found which were forwarded to DC.
The matter was inquired by the Excise Department,
And now
and
please give the-
after such inquiry, the matter has been forwarded to the District Commissioner to take appropriate action. Full stop. Para. Sri M. Chetia, Learned State Council, prays for little accommodation to take appropriate, to take instructions. Para. In view of the above and in the interest of justice, matter is adjourned to be listed on, we'll have it on 20, today's 19th. We'll have it on the 2nd of September.
My lord,
We'll get more than a week's time.
my lord, the state has not filed their affidavit, my lord,
Item number,
20.
Public Works Department,
Yes.
PWD, Mr. Chetia.
I think Mr. Gogoi informed my junior colleague that they got the instruction, they will be filing the affidavit shortly.
Mr. Gogoi, K. Gogoi, where is your colleague, Mr. B. Gogoi?
Uddhav mati diya hai.
If they want to file the affidavit, it will
Yes,
have
I
some
think
time.
that can wait. 2
But
weeks.
there
time
has to
may
be
be
some.
Now Buddha ne dinner to kaise affidavit to
No, there has to be a prayer for time. Senior counsel for the other side is informing, he is not before this court. But we'll pass the order, your you may. We'll pass in his presence. Liquor,
Focus thaki
First, please. K. N. Chaudhary, learned senior counsel for the petition, assisted by Sri P. Sharma, para. On the prayer of Sri B. Gogoi, learned standing counsel, PWD. Matter is adjourned by 2 weeks to enable filing of affidavit in opposition. Full stop. List on when? 2nd of September? Will it be too early?
Yes.
Or 7th of September?
Interim order.
7th.
Well, interim order is that will continue.
7th of September. Interim order passed earlier to continue till the next date of listing.
Deeply.
If there's a problem with the date, we'll let you know.
Lord shall kindly have it on 10th, or maybe next week. 14th.
Say 9th, is it okay? 9th? 9th? 9th, we'll see 9th. 9th. If there's a change in dates, we'll have it by.
The state was
22.
supposed to file an affidavit, man.
File the authorization in the course of
APDCL.
APDC.
Heard Sri P.K. Munir, learned counsel for the petitioners. Para. Miss, your name? As Bureau learned counsel representing the APDCL submits that the affidavit in opposition would be filed during the course of the day. Para. Let such affidavit be filed and tagged with the records and the matter be listed on next Monday on 24th.
Interim order.
Interim order passed earlier to continue till the next date of listing.
Deeply obliged.
May I give the lordship? In this case, though, my lord, today I have filed one short affidavit in reply. But petitioner executed work, my lord, as per.
You have filed a reply affidavit today,
Today, my lord.
served upon you, not tagged with the records.
No, my lord.
You could have called for the affidavit.
My lord.
You can have it when? Day after on Friday, is it okay? Friday along with the affidavit?
My lord.
Okay. Sri A.M. Borbhia, learned counsel for the petitioner, has submitted that a rejoinder affidavit has been filed today.
My lord.
Full stop. Miss M.D. Bora, learned standing counsel IWT, has acknowledged receipt of a copy of the same. Full stop. Let the affidavit be tagged with the records and the matter be listed on Friday.
Diploma.
Pursue.
I was directed to file a rejoinder affidavit. Today I will file rejoinder affidavit.
Last week when they took time for filing.
Okay, today they will file. What is your name?
Yes, sorry.
Item number?
26.
26.
You are not on record.
Um,
A. Sarif.
yes, sorry.
Sri A. Sarif, learned counsel for the petitioner, has submitted that the rejoinder affidavit would be filed during the course of the day. Also heard Sri K. Rahman,
Yes, sir.
learned counsel for the respondent number 14, as well as, no, you first read the state counsel. Also heard Sri M. Chetia, learned state counsel, and Sri K. Rahman, learned counsel for respondent number 14. Full stop para. Let such affidavit be filed and the matter be listed when? On Monday next? On 24th along with the affidavit.
May it please the Lord. Lord, I am appearing in item number 28. If your lordships would kindly have that item.
Yes. 28 good.
Lord, this the petitioner, my lord, he was following a tender process. He was engaged as a transport contractor, my lord, for
Mr.
carrying-
Barua,
Yes.
we are taking for disposal of what?
A short point, very short point is involved. Lord, in item number 28, where I appear, my lord, the petitioner was given transportation contract for 16 number of trucks, LPG carrying trucks. Now, my lord, the work order was issued sometimes in 2024. 25/4/24, and he was operating the contract
What was the tenure?
5 years.
5 years.
Up to 2029. Long litigation আগতে হৈছে এইটো না? Milord, prior to this writ petition, Milord, we filed one WPC, that is 6655 of 25, which was disposed of by this honorable court on 29/11/25, Milord, at page 268.
What was the earlier issue?
Yes, same thing, Milord. Procure's notice. Yeah, pro forma respondent.
Zero for whom?
Actually, Milord, they have a limited role, Milord. Tata Motors, Milord. Some inspection was carried out under their supervision. It was done, report submitted.
You may not have an effective role in the adjudication.
Yes. Now, if your lordship would kindly come to page 261, Milord. Para 11. Earlier, we challenged the show cause notice. Therefore, this order was passed. Taking into account above, the instant writ petition therefore stands disposed of with the following observations and directions. Petitioners herein is given the liberty.
This is the order of 29/11/25.
Milord.
It starts at page 2.
Yes, Milord. It starts at page number
257 effective date.
256, Milord.
No, it's 29, it's 24/11, not 29/11.
24/11, I'm sorry, Milord. 24/11.
24/11.
And the operative portion is at 261, para 11. Taking into account the above, the instant
Yes.
taking into account above, the instant writ petition therefore stands disposed of with the following observations and direction. Petitioner herein is given the liberty to submit the reply to the show cause notice dated 11/11/25 within 10 days from the date of present order, that is on or before 8/12/25. Respondent authorities, if any show cause reply is submitted within the period as above mentioned, shall afford petitioner an opportunity of hearing and thereupon decide the said show cause proceedings in accordance with law. So, my lord,
Basically, the proceeding was directed to be completed. Okay.
Instead of deciding on the Milord show cause notice,
Yes.
this honorable court was.
Now that has been.
There we filed our reply, Milord,
Yes.
and our impugn order was passed.
Of termination.
Of termination. Not only termination, termination, blacklisting, everything.
Where is it order?
Yes. Before that, can I have your lordship to the attention to the show cause notice, Milord?
Yes.
At page 219.
219.
Yes. In Mazare page 222, you have select part of the community. It is part in. 11/11/25. We bring to your attention that you have been awarded work order for transportation of Indian LPG cylinder ex Horpara for the period 1/5/24 to 31/4/29 for 16 number of packed trucks. It has come to our notice that you have falsified details for 14 number of trucks registered with your firm and offered in the above cited work order. The issue was taken up with the original equipment manufacturer, that is Mrs. Tata Motors, for verification of the chassis numbers being manufactured by them. This is how, Milord, my friend Jeroy's Milord part comes in. OEM Vidya's reply has confirmed that barring two number of trucks bearing registration number so and so, none of the other chassis of the truck bearing registration number so and so were manufactured by them as per their internal record. This clearly indicates that you have falsified the details of the truck. Then, my lord, eventually, my lord, at page 221, para 9, they're referring to, my lord, the different clauses which they invoked in this case at para 9. Therefore, in the light of the foregoing facts and circumstances and the applicable contractual provision, the referred truck have been suspended with immediate effect. Further, you are advised to show cause within 15 days of issuance of this letter, why panel action as detailed above should not be taken against you, and you will not be placed on holiday list and be debarred from entering into any contracts with the Indian Oil Corporation Limited, but not delisted, be not delisted from the list of the approved vendors contractors of Indian Oil Corporation for the following reason: for indulging in malpractice, fraud by submitting document statement of information being found to be incorrect and false, for committing representation of facts. So, my lord, these are the cases. Then, my lord, before I take your lordships to the show cause impugn order, my lord, let me place the facts in perspective. Now, what had happened, my lord? The petitioner's case is we have purchased, my lord, second-hand trucks. It was never our case that we have placed brand new vehicles. These are all second-hand trucks. And my lord, lordship knows nowadays all the particulars of a vehicle are available in two, my lord, forum, that is Vahan and, my lord, DigiLocker. Now, for example, my lord, we did check before purchasing the vehicle, and that I'll place, my lord. And vehicles were inspected also before inducting, my lord. Now, please come to page number 223.
Yes.
Now, kindly see, my lord, owner's detail, Subhas Kumar, address so and so, ownership individual. Then chassis number is so and so, engine number is so and so, maker's name Tata Motors, date of registration 11/12/18, tax valid up to 31/12/25. My lord, I as a
This is what copy, Mr.
this is,
Chaudhary?
my lord, this is that we have downloaded from, my lord, M Parivahan screenshot.
No, screenshot from what? M Parivahan.
M Parivahan. So, my lord, original owner's name is indicated. Then, my lord, his phone number is indicated. Chassis number is indicated. Engine number is indicated. And most importantly, my lord, maker's name is indicated as Tata Motor. What is there on our part to disbelieve this, my lord? Similarly, if your lordship would kindly come to page 224. This is the registration certificate.
This 223, you are having it as an illustration for one vehicle.
Yes,
One
affidavit for all, my lord.
All, okay.
Yes.
This, okay. For likewise, for like all the vehicles have been.
Yes. Yes. Please come to page 224, my lord. This is the registration certificate issued by Government of Assam. Kindly see, my lord, chassis number is there, engine number is there, and new owner's name is Hirok Jyoti Kumar. No, Jano. Ami? Subhas Kumar. Hirok Jyoti Kumar. And kindly see, my lord, on the right hand side.
Here the petition, Hirok Jyoti is the petitioner.
Yes. Hirok Jyoti petitioner, no?
Petitioner, Hirok Jyoti is the partner.
The vehicle belongs to farm, my lord.
Doesn't matter. You are connected with the petition.
Yes, yes. Now, my lord, kindly see month, year of manufacturing, 10 October 2018, and on top model Tata 1613 TCBS Roman 4. My lord, when M Parivahan reveals the identity, when the state's registering authority accepts it, my lord, is it their case that I have played fraud? Similarly, my lord, from page 225,
How did this trigger?
my lord, yes, it triggered because some complaint
any
was filed
was
by
there
some
any-
unsuccessful tender.
Was there any accident? No,
No,
no accident as such.
no
Or
accident,
malfunctioning or anything.
nothing. My lord, the some unsuccessful bidders, my lord, they filed complaint and the authorities apparently acted on it. Now, my lord, we have given all the Poribohan details and my lord, other details of the vehicle. Then my lord will kindly come to page number 243. Is a note OM issued by the Government of India, Ministry of MORTH.
Page?
Page 243. Kindly see the heading, my lord. Issued by the Government of India, Ministry of Road Transport and Highway, to the Principal Secretary, Secretary of the Department of Transport, etc., etc., to all states and union territories. Subject: acceptance of driving license, registration certificate, and other documents presented through DigiLocker or Poribohan platform. Now, my lord, please come to para 5 towards the bottom of the page. In the light of the provisions of the Information Technology Act 2000, it is requested to consider the documents available in electronic form in DigiLocker platform or Poribohan mobile app as valid under the Motor Vehicles Act of 1988 and be treated at par with certificates issued by the transport authorities. So, my lord, our reply before the authority was, these are second-hand vehicles. We never claim that these are new vehicles. Year of manufacturer and all, as is indicated in the, my lord, registration certificate, we relied on that. Now, my lord, they have passed an order whereby not only our contract has been terminated, my lord, even we have been debarred from participating in further tender. That impugn order is at page number 279. Oh, yes, sorry, my lord. Before that, if your lordship would kindly come to page 245 for a moment. Right. I'm sorry. Page 245, my lord. This is another communication by the same ministry, my lord, to the all the principal secretaries and secretaries of transport department.
Subject:
Acceptance of driving license, registration certificate, and other transport related information presented in electronic form. Para 2. In view of the above, a standard operating procedure as annexed may be adopted for ensuring compliance with the provisions of Rule 139 of the Central Motor Vehicle Rules 1989. Now, that connected thing is at page 247, Miller. At paragraph Roman 6 and 4.1, Miller.
3.6.
Yes, 3 Roman 6. These electronic records available on DigiLocker on Poribohan are deemed to be legally recognized at par with the original document as per provisions of Information Technology Act 2000. Roman 4.1, Miller. 1. Citizen can produce the documents or the other information either through DigiLocker app or Poribohan app. So these are all got statutory backing, Miller. And my lord, page 307 onwards, these are all DigiLocker certificates. 307 onwards, my lord. These are the vehicle number, then chassis number, engine number, name of owner, make, vehicle model, Everything is there. So we relied on these documents while purchasing and while submitting tender, and there was inspection also, Milord. And inspection was also done accordingly. There is a guideline to be transferred also, 282. Now, Milord will kindly come to the impugn order at 277. Page 277, Milord. Now, at page 277, they're referring to the show cause notice, Milord. Then we may skip that page. Then at page 278, Milord, they have given the vehicle numbers. Then please come to, Milord, the relevant clauses which they are relying. Clause number 7.2.2.10 of TDG regarding entering into contract based on forged documents, false information.
Where are you reading?
Page 278, Milord.
278.
277, it basically refers to the, Milord,
No.
show cause notice. Then at page 278, they're referring to the clauses which enables them to, Milord, terminate or take the impugned action according to them. Clause 7.2.2.10 of TDG regarding entering into contract based on forged document.
TDG means? TDG.
Transfer the guideline document. Transport. Oh, I'm sorry, discipline guideline. Transport discipline guideline, I'm sorry.
Yes.
So they're referring to these two clauses, Milord, 7.2.2.10 and clause 82F. It reads, in the event the transporter or his employee and agent are found indulging in malpractices, irregularities, forgery of documents, and misappropriation of corporation's property in the form of LPG cylinder, filled or empty, pressure regulator, etc. So, Milord, they're trying to invoke these two clauses. Now, they're referring to the reply to the show cause notice dated 25/11/25, Milord. Now, they have referred to our stand in the, Milord, reply. Then, Milord, operative portion of the reasoning is at page 279. The reply dated 25/11/25 against the show cause notice dated 11/11/25, the documents submitted, submissions given during personal hearing dated so and so, and additional written submissions submitted on 29/1/26 were carefully examined by the three-member committee comprising of officers of the corporation. The committee is of the opinion that submission made by you are not acceptable due to the following reasons. Though RCs in respect of 14 number of trucks were issued by DTO mentions the manufacturer name is Tata Motor, however, Tata Motor has confirmed that the chassis number of the said 14 number of trucks were not available in their internal records. Milord, out of the 16 in respect of 2, they did not find any infirmity, Milord. It was in respect of 14 that they found. So the first ground is, though RC mentions it as a Tata make, but the original equipment manufacturer, that is Tata Motors, have said that these are not Tata make. 2, Tata Motor, that is the original equipment manufacturer, and the 14 number of trucks are their proprietary item. Since they have clearly confirmed that chassis numbers are not available in the records, even though RCs mentioned the truck to be Tata make, it cannot override the confirmation from Tata Motors. Well, I think it should have been other way around. After the statutory authority, Milord, confirms its existence, how can by an executive fiat, Milord, somebody can say it cannot be? 3, Section 1101I of the Indian Motor Vehicle Act, the central government is empowered to make rules regarding
embossment of chassis number and engine number, and date of manufacture. Since this usually happens at the manufacturing stage, the OEM's physical marking is hereby considered as the proof of the vehicle's identity. Since in this case, the OEM itself has confirmed the non-existent chassis number, hence RC, which is only a record of particulars of a vehicle, cannot be taken as conclusive evidence regarding the identity of the vehicle. Possible kindly mark this word conclusive, my lord, it will have some relevance. I'll come to it a little later. It is the responsibility of the party to check the vehicle particulars, make chassis number were not falsified. Even though the trucks were previously contracted with IOCL, the present action is being taken on the basis of a vigilance complaint, which has been substantiated, and the vigilance department has confirmed that details of the trucks are not available in the records of the OEM, that is Tata Motor. My lord, this is a very vital point for us, my lord. There is no mention in the show cause notice regarding this vigilance complaint. Now, it is only in the final order, my lord, there is a reference to vigilance report. That means, my lord, it was never given to us. We do not know what it contains and what vigilance department did behind our back. Oh. Now, my lord, having regard to the facts which have unfolded, my lord, my humble submission is, my lord, first of all, we are not guilty, we are not party to any fraud. Let us be very clear about it. We are bona fide purchaser of vehicle. We purchased it second hand, and we have checked the particulars from the M Poribohan and, my lord, with DG Locker, and the, my lord, registration certificate which has been issued by the registering authority. Now, my lord, we as a bona fide purchaser, how can we be blamed if there is something wrong in the process? If I am to be penalized, then everybody else has to be penalized. Then they must take action against the transport department also. How can it be, my lord, how can we visualize a situation when we rely upon statutory, my lord, documents, and yet, my lord, an entity under the government disbelieves it? It can't be. It's irrational. Number one. Secondly, my lord, now they say in
Mr.
ground number.
Chaudhary, just to cut things short,
Yes.
are you in a position to replace your vehicle?
Yes, we are.
You are?
Yes, we'll do that.
Mr. Chaudhary, Mr.
Yes.
Borwa?
In fact, I was coming to that, my lord.
See, you may have a case
Hmm.
of verifying the document, verifying the vehicles. It plays a very important role. But the petitioners cannot, from the
blamed.
facts narrated, cannot be faulted with. Because apparently the Tata Motors have been written all across. Now, from the internal records of Tata Motors and based on a vigilance report, you have come to a conclusion that the documents, either in the soft copy or hard copy, is not conforming to the actual vehicle which has been used. There are no instances of any accident or any malfunctioning. But nonetheless, you may have a stand in insisting that a Tata vehicle will only be supplied. If they are have the capacity to replace the vehicle,
We'll do that, my lord.
do that. But the action we
Too
cannot
harsh.
endorse, either of blacklisting or taking
Termination.
penal action. But use of those vehicles may be an issue on the other aspect of
Yes.
safety and public maintenance. So on this issue,
Only one point, madam.
yes,
I agree on that point which
Yes.
your lordship is suggesting, because that is.
this will be balancing everything. You'll also be satisfied.
Page 297 also.
Hmm?
Page 297.
Yes.
It supports, let us see this case also, my case also.
Hmm.
7.2.210.
Hmm.
Enter into the malpractice irregularity.
Yes.
Just read that.
Hmm.
The particular malpractice is entering into contract based on false documents, false information.
Hmm.
Two aspects. One is the actual intent of committing a fraud.
Hmm.
One is false information, which may misrepresentation, which may not be intentional. For the first instance itself, contract to be terminated and truck and transporter will be blacklisted. That is the provision. However, down below, however, if the complicity of the transporter is detected in case of occurrence of any of the above malpractice relevant to the whole contract comprising of all the trucks belonging to the concerned transporter shall be terminated, and the concerned transporter and all their trucks shall be blacklisted. So therefore, I agree on a plain reading of this to be read with 7.2.10. It may be that the entire contract may not be terminated. It may be terminated only in case of complicity, which is a disputed question of fact. IOCL is not in a position to argue that they were complicit. The only point is that they have not filed any FIR against the previous owner for selling them a fake truck. But my lord, only notice one point is that since we are duty bound to act fairly, there are other bidders in the wait list with their respective trucks. So therefore, the IOCL may be given the liberty to induct the trucks based on the age, because the age is a crucial point. The reason for
They're in a position to give better trucks of Tata Motor.
We'll provide better.
They'll provide.
if the IOCL will examine, if they are found better than the other trucks on the wait list, they may be.
No, that will not do.
Other bidders will not, that will
They'll
be
not do. That
opening the
will,
Pandora's box.
and Mr. Chaudhary has not very specifically argued. You come to 279.
79.
There is no conclusion reached or
Yes.
satisfaction arrived that they are indulging in either fraudulent practice or
Exactly.
falsification. There is no finding.
We cannot.
They themselves say cannot be taken as conclusive. That's why I was about to make that argument.
I agree that we cannot establish complicity because we do not have materials to establish complicity.
Oh.
It's just a mobile Parivahan app.
See, what is the charge? The charge has to be either fraudulent documents or misinformation, false information. Prima facie, neither of those two are attracted. You even do not come to a conclusion that those two ingredients are there in the discussion in 279. This 1, 2, 3, 4, and 5 are the discussions.
Yes.
Nothing more than this. The conclusion part.
Yes.
Read any part of this.
Yes.
From where you have come to a positive satisfaction that yes, they have indulged in giving a forged document or giving a false statement. There was an internal complaint or internal inquiry by you with Tata Motors when from their records they said we do not find a truck of this nature in our records. That may not be true also. We do not even know to that extent, but let us assume that is a
They
correct
say it's
information.
not available.
Not available. That may not be correct, but let us assume that it is a correct information. You have that much of right and liberty to ensure that the vehicles are proper or of a particular standard which you insist. Now, Mr. Chaudhary and Mr. Pathak also would be in a position to replace those vehicles with vehicles which you will be inspecting.
But my lord, the simultaneous direction should also ensue regarding the fate of the trucks which are admittedly.
They'll be removing those.
Yes. They'll have to be removed.
This
They're removed.
the 14 in my case, I'll have to replace.
Replace it.
They cannot, because they will be again offered in another tender.
No, they'll replace those.
In my case, Lordship, out of the 7 vehicles, only 2 there is a problem. The rest of the 5 vehicles, your Lordship. Only 2 out
How
of
many
4
petitions are there?
4 petitions.
আমার কি total?
39.
Giving the numbers.
How many vehicles you have?
In this item, there are 14. We are giving the numbers. There are 3 petitions, and I think
In my petition, there are 7 vehicles, only 2 are defective.
Can you give a list?
I'll give it. Numbers and Miller defective.
No, not required. Total number of vehicles.
Total
Total number of vehicles which have been given, and out of this, how many numbers of vehicles have been found to be alleged to be defective or not matching to the Tata requirement? Mr. Chaudhary, you appear for whom?
I'm appearing for 3 items. Miller.
28, 29 and 30.
Mr. Deka, please give the list.
Yes.
And Pathak for 1. Okay. We'll pass that order. We'll
Yes.
balance it. Okay. And madam. What is it, the report? No, what is the report? Tell us what is the report.
The second, third paragraph, may I read, my lord?
Yes. Now you can just give a gist. The certificates which they are possessing, registration as well as DigiLocker and M-Parivahan. matching. It may be a case where Tata has misplaced the record.
They say not available.
Not available. Tata, it may be unpressed. For that, can you take such a drastic action? That may not be fair.
And but can't we see extent of amount we have invested, my lord, in procuring the vehicles and all?
Well, they are talking about their records. It is already uploaded on the M-Parivahan app. That is their record. That is admitted fact.
Yes.
It is uploaded, but on physical inspection, the chassis was found to be matched in order, defaced. So meaning thereby there was an underlying chassis number, engine number, on which there is an overwritten a subsequent engine number and chassis number, which was subsequently matching with the
Have you done this for all the trucks?
all the complaint trucks. Yes, all have been.
No, not complaint. All trucks.
That is not being done.
Do that. Many things will come. Many things will come out.
Very much
That is the point.
That's a national problem. There are
Many things will come out. Before you actually induct a truck, make a thorough, at least those are the basics. Even if you buy a vehicle, old vehicle, you first see the chassis number, whether it's there or whether it is.
And before
interpolated.
inducting, these are inspected, my lord. Thereafter only LOI was issued.
Okay, we'll pass the order, not today, we'll reserve it for judgment, just for the namesake, but very shortly we'll put the judge.
Yes.
Okay. Third.
Diploma.
Okay, Chaudhary, please give the list. Here is appearing.
This should contain the names of the defective vehicles only, my lords, or
Only the number of vehicles and the numbers found to be defective. Okay, if you give the details also, no problem, you can incorporate in the judgment. What are the details of the vehicle given? Which of these vehicles have been found to be defective? And order is the same?
Yes, yes, yes.
Same order?
Same order.
different order, same date.
Same date, okay, same date.
As per the report submitted by the MDI, as part paragraph report.
Sir, लिखित person. MD Bora Learning Training Council Transport Department has submitted that written instructions have been received, as per which the records of the Transport Department matches with the records submitted by the petitioners.
Corresponding to the RC and Bahan portal also.
Corresponding to RC and Bahan portal. Okay.
Diploma.
Your the document is there in on.
Yes, my lord.
I've
submitted
Rakiba
all my documents.
and Barua for
IOC.
IOC. And you are also there. Union of India. SS Roy.
The inquiry report only.
Inquiry report, yes. Written instructions. Name B. Saha on behalf of Mr. J. Roy for the Tata Motors.
Diploma.
Okay. The hearing is concluded, judgment is reserved. Into Azay di din de. List kon dibo diyo. List dibo ha, kune kar kane appear hoise. Ekhine already mariye thoi dibo. Yes, item number. What is 31?
Lordship, in this matter, the arbitration clause is not applicable based on the facts of the chronological facts of the case.
Mr. Gogoi.
It breaks na another portal. It can be it's on a next week.
There's an arbitration clause. Okay, Mr. Gogo is not there. Why is it not maintainable? Why is it maintainable? Arbitration clause is there.
Lordship, my senior is unwell to appear before.
Who is
this
your
court.
senior?
P. Bharadwaj.
Plavan Bharadwaj.
Yes.
Okay, we'll have some other days. Friday? Okay. A prayer for adjournment has been made on behalf of Sri P. Bharadwaj Learned Counsel for the petitioner.
Lordship, we are filing affidavit in reply today.
Full stop. What is your name?
B. Parashar.
Ms. B. Parashar, Learned Counsel representing Sri Bharadwaj, has also informed that a reply affidavit would be filed during the course of the day.
Yes.
Sarah? let such reply affidavit be filed and the matter be listed on Wednesday next. Wednesday next. Wednesday will be 26th. Khula ase na? 26th. Or you can have it on Tuesday also. Or Wednesday, 26th. You find it today.
Okay, today.
Our affidavit has been sent for vetting, my lord, now 1 week's time.
Excise Department.
For Forest Department.
What is it, Mr.
Stone crushers, all my formalities has been given, but license is not provided.
Okay, heard Sri P.K. Roy Chaudhary, learned senior counsel for the petitioner assisted by Sri, your name?
Yes, sir.
S. Ahmed. Para, Sri I. Borthakur, learned standing counsel, Forest Department has however submitted that the affidavit has been prepared and sent for waiting and will be filed shortly, full stop. He accordingly prays for and is granted 2 weeks?
2 weeks.
2 weeks time to file such affidavit, full stop, list on 14th of September.
Over.
My lord, today we have filed affidavit, it's on record, my lord.
You have filed affidavit today? Copy served upon you?
Court record, I have.
Okay, copy has been served upon you? Would you like to file rejoinder affidavit?
No, my lord.
Because lordship, we have written to the NIC long back on 31st of October 2025.
If he is not requiring to file any rejoinder affidavit, you can take it for disposal if you want.
Yes, my lord.
But here, my lord, the appearance of respondent number 3, my lord. Respondent number 3, my lord.
Who is free?
My lord. NIC, my lord.
NIC.
National Informative Center, my lord.
Served.
Sir, my lord.
So is
Last occasion also, my lord.
Appearing. Government is appearing for NIC.
yes, yours, their stand will be required. Their stand will be required.
We have written to the NIC,
Yes.
but their response is.
Yes, you get your instruction. It can be resolved perhaps.
Yes.
Okay.
Very lordship.
Heard Sri D.J. Haloi, learned counsel for the petitioners. Full stop. Miss. Also heard Miss M.D. Bora, learned standing counsel, Transport Department, who has informed that affidavit in opposition has been filed. Full stop. She has also submitted that the matter has been referred to the NIC and response is awaited. Full stop. Para. Sri M. Chetia, learned State Council, representing the NIC, is directed to obtain instructions in this matter. Full stop. Para. List on
Friday, madam.
Friday, not Friday, no, Wednesday next. You have some time to get the information. When is the 26th? Hi.
Of like.
Yes, Mr. Chaudhary.
With your lordship, my lord, the Water Resource Department is required to file an affidavit, my lord, that has not come.
Not filed.
We're humbly praying for some time to file it.
Have you got the instructions or not?
Yes, ma'am. Where is it?
Prepared or not affidavit? Not prepared.
David is not yet prepared.
Prepare it if you have got the instructions. How long do you retain required to prepare an affidavit? Heard?
Deputy
Served copy.
Commissioner has filed, my lord.
Okay. Heard Sri M.K. Chaudhary and the senior counsel assisted by Sri Medhi. DJ Medhi for the petitioner. Para? While the district commissioner, which one? Which district? Which district?
Murigaon district.
Murigaon district has filed an affidavit yesterday, comma. The affidavit by the Water Resource Department is yet to be filed. Full stop. Your name? Your name. Please give it to, on behalf of RM Das.
Yes, ma'am.
Sri So Learned Council, appearing on instruction of Sri RM Das Standing Council, Water Resource Department, prays for, and is granted 2 weeks time to file the affidavit. Full stop. Para. List on 14th,
My lord.
14th September. File it before that.
Okay.
May I please, Your Lordship? My lord, as per the last order, my lord, they need to have
place the record, my lord, before the honorable court.
Notice was issued.
Notice was issued and
Mr. Sharma is not there today. We'll get the records. When? Records will come from where? Kamrup?
Kamrup, Morigaon, my lord. Here is
Morigaon.
Kamrup. 6 months.
6 months. When can you get the records?
Friday or maybe other.
We'll have it on Wednesday next.
Yes.
Wednesday next, okay. Hearts free
Instead
J.I.
of Wednesday,
Barbhuya.
can it be Tuesday, my lord? Because records, if
No,
they,
no problem. Wednesday matters are in fact over early.
lordship.
Hearts free J.I. Barbhuya, learned counsel for the petitioner. Full stop. Notice was issued on 27/7/2026 and today is the returnable date. Full stop. There was also an observation for consideration of the interim order for which the records were directed to be produced. Full stop. 3. Your name?
K. Das.
K. Das, learned counsel appearing on instruction of Sri P. Sharma, has however prayed for little accommodation for production of the records. You, Mr. Hussain, for?
Response number 4.
Sri M. K. Hussain, learned counsel for the response number 4 is present. You have filed affidavit.
I'm filing.
Who present who prays for time to file affidavit. Full stop. Para. Let such affidavit be filed. Para. List on Wednesday next for production of the records. Wednesday will be 25th, 26th.
And also for the consideration of him.
That is already there. We'll see.
Lordship.
Yes, Mr. Das.
Petitioner's lawsuit PDS license has been suspended because of an lawsuit.
Mr. Chetia. Suspension of PDS license.
Lordship, that today the matter is fixed for consideration of my interim PR lawsuit. And also, and there are some, also I also brought some judgment laws.
How many days? 26, 2026.
Lordship.
It's more, not even a month. So let them file this.
Yes, ma'am.
Okay.
2 months, Lordship. 2 months.
90 days is the limit.
Lordship, 90 days.
Have you initiated any action?
My lord, we have received the same,
Did-
my lord.
This is under the 1984 orders.
Lordship.
Yes.
Lordship.
Okay. Heard 3 S.K. Das, learned counsel for the petitioner, para. 3 M. Chetia, learned state counsel, has however informed that instructions have been received and he accordingly prays for time to file the affidavit in opposition. What's the para? Considering the subject matter involved, let such short time involved, let such affidavit be filed within a period of
10 days.
2 weeks from today. Full stop. List on. Today is 19. 2 weeks will be on. Can you have it on 2nd of September? 2nd September.
Lordship, the interim order will be considered on the next day.
Let it be there. It's already there.
Obliged.
Puntu matter. Puntu matter. Item number? Portable is good. দুটা বজাত বুলি কৈছিল নহয় এডিডাছ নহয় এইটো হেৰি আছে কেন চৌধুৰী Mr. Chaudhary, we could have done today now itself. Where is Mr. Gupta? Is he there? Okay, দুটা বজাত আহিব কৈছো যদি আহিব এই ডিটেকশনটো এতিয়াই দি দিম হা Under the facts, aforesaid facts and circumstances and the discussions made, this court is of the opinion that no case for interference has been made out and the petition is dismissed. Interim order stands vacated. Records be returned back. Record clearly.
62. Other side. Made prisoners. Basically, my lord, NF Railway issued an NIT for providing housekeeping services, that is providing bedrolls and all. Now, the petitioner along with others, my lord, qualified in the technical bid, but in the financial bid, my lord, the petitioner was held to be L2. And respondent number 4 was adjusted as L1. Now we are assailing that decision of the NF Railway Authority in declaring or adjudging respondent number 4 as L1. Our basic case is, my lord, a hidden criteria has been adopted while evaluating the financial bid. If your lordship would kindly come to page 114, my lord.
114.
Yes. This is the schedule of rates. On top, lordship will notice the name of the work, Integrated Housekeeping Service of Brahmaputra Mail and any express maintained.
Madam, have a seat. Why don't keep on standing?
Integrated Housekeeping Service of Brahmaputra Mail and any express maintained at Coaching Depot Kamakya of NF Railway for a period of 2 years. Now, estimated value of the work is 21 crore 87 lakhs and odd. Now, these are the schedule of items, my lord. We are concerned with schedule 2. LS provision money ki LS money. Now, schedule 2, my lord, provision for bonus to staff. Now, as per the NIT, my lord, as per our understanding, this component of bonus has to be quoted at par. That is 1 crore 34 lakhs 98,565.61. Please come to page 117, my lord.
You
I'll
have
read-
quoted this is at par.
Yes.
Rupees 1 crore 34 lakhs 98,000.
Yes, 1
Five
crore
six five.
34 lakhs 98,565.61. And the tender conditions also says so, my lord. At page 117. I'll read 12, 13 and 14. The bonus at the rate of 8.33% of the minimum wages, whichever is admissible as per Bonus Act, made by the contractor for Coach Mitra staff supervisors shall be reimbursed to the contractor only after submission of proof that it has been credited to their account, subject to eligibility of the staff for payment of bonus as per the prevailing Bonus Act. Now, this is important. Bidder should quote at par against item number 1 of the schedule 2 of the rate schedule. Quoting below par against the bonus item will lead to summarily rejection of their offer. In case any rebate offered by the bidder over the gross quoted value, each individual item will be examined considering the rebate percentage. In such case, if quoted value including rebate percentage against the schedule 2 of bill of quantity, that is bonus for provision for bonus, is below par, then their offer will be summarily rejected. The provision for bonus made in the tender is lump sum, as actual bonus amount is not accessible at the tendering stage and can be ascertained only after execution. As there are possibilities for a particular skill or highly skilled category staff for working less number of days on average per month to not meet the monthly wage of 21,000. In such case, particulars of even staff, even skill, highly skilled will also be eligible for payment of bonus as per the Payment of Bonus Act. Thus, provision for bonus for all category staff has been incorporated in the tender, whereas payment to be made on actual basis as per feasibility of the payment as per Bonus Act. The bidders are advised to quote at par against bonus item will all possibilities for ensuring smooth compliance to the act. Milord, 2-3 things, Milord, clearly emerge from these conditions, Milord. Number one, now the payment of bonus is not automatic. Number one, proof that money has been credited in the respective account of the staff is there. And secondly, Milord, that the person is eligible. The person who will get the bonus, he must be eligible under the Bonus Act. Secondly, Milord, there is a provision for giving rebate. But despite that, the bonus component has to remain static, that is at par. The idea is very simple, Milord. At this stage of tendering, it is not possible to know what would be the extent of the bonus that would be required. It all depends on, Milord, once the contract is executed. So therefore, overall, Milord, the picture which we get and which is very intelligible is a clear case where there is a prescription that whenever you quote for bonus, it should be at par. Now, in this case, Milord, what had happened? The respondent number 4, he has given a rebate. Now, your Lordship will kindly come to page number 152. This is, Milord, the result of financial bid opening. Now, as I have already submitted, Milord, we are not concerned with Schedule 1. However, Milord, it appears in Schedule 1, Urmila International is the respondent number 4. His bid is higher than that of the petitioner. He has quoted 18 crore 19 lakhs 24,416, whereas Tharu, that is the petitioner at the last in the column, Milord, I have quoted 18 crore 4 lakhs 76,139. So as far as Schedule 1 items are concerned, I am L1.
What is this 152? Comparative statement.
No, Milord, it's the result of the financial bid opening.
Comparative statement.
Comparative, yes, comparative statement following opening of the price bid. So, Milord, what clearly emerges is, as far as Schedule 1 quantities are rates are concerned, I am L1, he is L2, because he is approximately 15 lakhs more. Then Milord will kindly come to page 152. 3. 3. Because at last line of the page number 152 is the Schedule 2, Milord, provision for bonus to staff.
Page?
Page number 153. Milord.
Next page.
Yes. Now, LS provision for payment of bonus to staff with GST. Now, the fixed amount is, Milord, as we have already indicated, 1 crore 34 lakhs 98,565. The other bidders, except respondent number 4, they've all quoted at par. Now, what he did, my lord, he quoted 1 crore 36 lakhs 7,903, but here he has given a rebate of 0.8%.
Rebate on what?
Rebate on, my lord, rebate, actually, my lord, if it is a rebate, it has to be across all the items. All the items. Because that clause 13 clearly says so, my lord, at page 150, 117, which I have read.
Rebate on gross value.
Yes.
Gross value will definitely include bonus.
Yes, one.
Bonus.
Bonus. Bonus. So, my lord, now what they have done, he has quoted 1 crore 36 lakhs and 07. There he has given a rebate of 0.80%. Taking note of that, my lord, his rate becomes 19 crore 39 lakh 68,000. Whether my rate becomes, my lord, 19 crore 39 lakhs 74,000. So there is a difference of,
Where are you in the
page 153, my lord.
No, R4 we have said.
R4 will be, my lord, that after 0.81%, next column, he should have quoted one.
No, where is your, what is your name?
I am, my lord, the last column, Tharu, and he is Urmila.
Oh, yes, Tharu. Yes. Tharu Arnakulam. Yeah.
I am, my lord, last, I am in the last column. And just after that 0.81% and above is the rate which is quoted 1 crore 36 lakhs 7,903.99. On this amount, he has given a rebate of 0.80%. Therefore, it becomes total it becomes 19 crore 39 lakhs 68,061. That way he becomes L1, taking note of the rebate. Otherwise, my lord, I am L1. Last column. I am 19 lakhs 39,000. 19 crore 39 lakhs 74,705. My lord, our very simple case is, in fact, I'll just place few tenders which has been issued by, my lord, railways. If your lordship would kindly have the additional affidavit which you have filed, my lord. My lord, we'll be referring to 3 other NITs, my lord, issued by the Indian Railways, where there's very clear at par means at par. Their stand is it can't be below, it can be above.
Now we are trying to understand the mechanics here involved.
Yes.
He would definitely say, which we remember, that the restriction is should not be below.
No, restriction should be at par.
That he's saying it should not be. So above is possible. But what is the internal thing they are trying to do? Price, he is more than you.
Yes. Otherwise, the I becomes L1.
Sans the bonus part, if you remove the bonus part, price, you are lower than him.
L1.
He gives a bonus of a higher quantity and he makes a total rebate of 0.8% from the gross value.
Gross value.
So, Mr. How is it possible? This is only playing with some arithmetics.
Here the question is on the
It's only playing with the numbers.
Here the petitioner has not given rebate.
No, rebate.
One of the issue,
Rebate is you cannot give rebate. You can give rebate. What is the rebate of respondent number 4?
Given rebate.
No, their rebate is what?
And after giving
0.8.
rebate, they are L1.
Rebate is given at what stage?
At the time, it is there in the tender process itself. At the time of bidding, it is there.
It is, it's a
It is
part,
The process is, it is available. The time of making the bid, that option is there to give rebate. Admittedly, they have not given that.
no,
rebate.
Mr. Mr. Let us understand. At what stage the rebate would be given?
In the tender
Rebate would be
process.
given if you see that there is a competition. I am willing to come down.
No.
So otherwise you give a rebated date. Why give 100 rupees and say I'll give a rebate of 5 rupees? So quote 95 rupees. You have not quoted, you means R4 has not quoted 95, he has quoted 100.
No.
When did the component of rebate come? After opening of price bids.
No, at the time of submitting the bid,
So what is the question of rebate?
rebate is the minimum wages that has to be paid. Two schedules as is there in the tender process. One is relating to bonus, one is relating to the minimum wages. The minimum wages rates that will never.
The
go
minimum
below
wages,
that.
there is minimum wages, there is no other component. There is only a component of bonus. Which is no, bonus has to be calculated on the minimum wages. There is only the minimum wages concept comes in. If you see the expressions used, bonus has to be calculated on the minimum wages. So a calculation each of the bidders will make on their own. And bonus, there is a requirement which senior counsel said it has to be at par. You may not agree with him. You may not, but ultimately,
Even after that,
when does the rebate stage come?
At the time of submitting the bid, there is a provision for giving the rebate. It is there in the tender conditions also, that the rebate can be given by the bidder. And the provision for rebate is there, because there may be variations in the work.
Where is the rebate condition?
In 117, clause
If
13.
there is a scope of rebate, that has to be transparently done, giving opportunities to all.
Yes. It is there.
Now, otherwise it will defeat the entire essence of having a fair competition.
I have checked,
Yes.
that is there.
Where is it?
That, even,
What stage you will give the rebate? It has to be given only after
It is
knowing
in
the
the
competition.
yes,
Somebody is more than me, I am willing to give less.
It is in the portal,
No, let us see.
So far as the condition is there, it is at page 117, paragraph 30. The provision
No,
for giving rebates.
the court will not mind at all having a better price. Ultimately, public interest is there. But having a better price at the exclusion of somebody who is not even taken into the loop, that will not permit.
No, they were aware of the provisions of giving rebate. They have not given the rebate. And after giving rebate, they are L1.
Let us see the proceeding. Mr. Gupta, proceeding.
The proceedings.
This is the culmination of the proceeding. That rebate you have already incorporated. He has given this rebate, no rebate from him. Let us see the proceeding.
The minutes,
Yes.
minutes. So this is the proceedings,
Which one?
Turn to page 7.
Yes.
Page 7, this is item-wise details quoted price by technically qualified bidders are listed out as follows. Schedule 1 is integrated housekeeping. In the top of the tabulation, we see Messrs. Urmila International.
Yes.
Intersay rank L1, including rebate of 0.8%.
Yes. When was the rebate? At what stage?
At
Urmila is R4.
Yes,
Urmila is L1.
R4, yes.
R4.
R4. So this is including rebate, this is the rate which has been arrived at, and the grand total comes to 1939.68. The rebate is as
No, that we have
that overall schedule, overall items.
that we have seen.
And it comes to 1939.68.061, 11.3380 below the value as per the tender.
We want to have a look at the minutes. How did you arrive at? What was the stage when rebate was given?
Now, for that, well, I will just produce a calculation which we have done from this line itself. Well, how that calculation has. been
Just a
done-
minute, please. Yes.
Well, I have given one tabulation, my lord, which we have prepared so as to, well, show how that rebate is applied. Because, my lord, in the minutes of meeting, that would not be reflected. But, my lord, from the minutes of meeting, we have extracted this, my lord, the tabulation.
Now, this, we want to know the decision-making process. These are only the culmination.
Calculation, yes.
The culmination we do not need.
My lord.
We are not interested in the decision. We want to know how we have taken the decision.
The calculation, my lord.
The decision-making process,
My lord.
what was taken into consider, what stage rebate was given, was the scope given to him?
My lord, rebate was given, my lord,
These which are, that will not make any difference. These are already before us in the repetition.
my lord.
These facts are already before us, that he gave a rebate 0.8 on the gross value. So ultimately, R4's rate became lesser than the rate of the
My lord.
petitioner, and therefore L1.
My lord.
That we have understood.
At what stage
What
rebate
no-
is applied, my lord, that is, my lord, from the certificate. This is, my lord, when the bid is submitted online. My lord, this is by the L1, respondent number 4. This is in the online system, my lord, when the bidding is made,
Yes.
my lord, it is reflected, my lord, the bid rate, bid amount is there, and my lord, will see, my lord, rebate on the total value at the bottom.
Yes.
This is all in the inbuilt in the system, my lord, online bidding system. This was quoted by R4, 0.80. Accordingly, my lord, the value, net value of the bid comes down to, my lord, 1939,68061.
Will not that amount to tampering with the requirement to not to have below par of the bonus?
No, my lord.
Rebate is not on the price, rebate is on gross, which will include the bonus.
Yes, but my lord.
What percent, what would be the bonus amount of the respondent number 4 if you have a rebate of 0.8?
My lord, it would be. My lord, at page 7, which I have.
Mr.
Given, page 7 of the minutes of meeting, which I have given. My lord.
Yes. No, can you make the arithmetic, Mr. Rahul? Gautam? The bonus amount which has been quoted by R4.
Page 146.
If you give a rebate of 0.8.
46.
146.
We have submitted a representation to that effect.
146. Let us see. 146.
Yes.
It still remains higher.
Higher. It's not par. Page 146, my lord, while filing the representation, we have pointed out. Provision for bonus 1.3, 1 crore 34 lakhs 98,000. 8% becomes so and so. So this is the quoted rate. Then, my lord, they becomes 1 crore 34 lakhs 99,000.
No, we are not asking this. Please,
After that is there, my lord. At page
let me convey it properly. See, respondent number 4, you find the various rates.
Yes.
One for bonus, one for the price.
Huh.
Now bonus, their rate is above par. Their rate is, what is their rate? Bonus?
Bonus is, my lord, 134,98,565 at par rate.
Yes. No, their rate.
Their rate is above the par.
That is it.
Yeah.
You make a deduction of 0.8. How
Yes.
much does it become?
It becomes, my lord, 1 crore 34 lakhs 99,040. Not at par.
That is there at page 7, my lord. Minutes of meeting. Exactly same.
1 crore?
34 lakhs 99,040.76. But this is not par. You may do whatever you like. It must be at par. That is our case. And other tenders are of Indian
Where
Railways.
have you done the calculation?
Yes, my lord. Very simple.
Or where is it?
Yeah,
Yes,
page
sir.
146 of the writ petition.
Okay. Provision for bonuses 134.
Yes.
L1 has quoted 136.
So 1
Very
my lord, deduct 0.8%, it becomes 134,99,040. So it's higher than my lord the at par rate of 134,98,565.
So how come the total amount has become lesser than you?
The grand total, my lord.
As a whole, other amounts. No, my lord, question is, my lord, my humble submission is very simple. Now, are you not adopting a hidden criteria? You have not mentioned that if it is not higher, we'll accept it. It's a hidden, that it could be higher is a hidden criteria. How can I adopt this? And when your other tenders says otherwise. For example, if your lordship would kindly come to page 241, my lord.
Okay, we'll come back to you, Mr.
Yes.
Gupta. Okay, let us complete
Yes.
this.
Please come to
page
240. My lord, please come to
248.
page 239.
239.
Yes, it's a tender issued by Miller Railway. Now please come to 241. Space. Please come to page 240, Miller. Last column. Same tender. Custom bid so and so. Mechanized cleaning, intensive mechanized cleaning of coaches at BBQ depot, including GST 18%.
Which one? Serial number?
Page number 240, Miller.
Serial number?
Page 240, Miller. Last column, Schedule 7.
Yes.
Custom bid for services, Schedule 7, Provident Fund, ESI, bonus. So and so, everything is included. Then Milord will kindly come to the next page. Note. Bidders are requested.
Just a minute. 240, which?
240, Schedule 7, last column.
Schedule 7.
Yes.
Last row.
Last row.
And custom bid in so and so, component of labor engaged in mechanized.
Bonus. So everything is included, Miller. So at par.
Where do
and
you
lump
get
sum contract.
Where do you get bonus here? Okay, bonus is there. Okay, yes.
Then Milord will kindly come to the next page. Bidders are requested to adhere at most during the bidding as stipulated above. At par, the bidder shall quote as per the mentioned schedule cost only. If quoted above or below to the mentioned cost, then bid will be rejected summarily. So in the present tender, Milord, that it can be higher, that is a hidden criteria. Leaving some leg room for them to, Milord, play. Then, Milord, another tender at page number, it starts at 242, Milord, and the relevant portion is at 243. Lump sum, Milord. In the first, Milord, column, in the last one, lump sum description. Cost of bonus of OBHs and linen.
You are at 242.
243, Milord.
243. 243, which one?
And Milord, in the first tabulation, Milord, last column, lump sum. Towards the middle of the page, Milord, little upper side. Lump sum description, cost of bonus at page 243, Milord. Last column of the first tabulation.
Description.
Description.
Cost of bonus.
Yes. Cost of bonus for OBHs and linen distribution staff to 464 of so and so base rate 8.33 over minimum wages of 7,000 monthly sum. It will be treated at par and tenderers are advised to quote at par only. Then Milord, one more tender at page number 244. And the relevant portion is at page 246. Serial 8, my lord, towards the bottom of the page.
Yes.
Bidder shall quote at par only for Schedule C. So, my lord, you have indicated that you can't quote below, but the higher part, that is a hidden. And it's well established now, my lord, because of the extent of transparency that is required in these matters. Whatever norms you fix for others, you must also follow. It can't be that only bidders are required to follow the norms, you are not required. Para 11 of International Airport Authorities case. So, my lord, here is a clear case. You have kept some discretion for yourself, which you normally should not retain in a tender matter. Now, if I would have known, or if the respondent number 4 would have known that no, I can quote only at par, and why not this clause was made very specific. Therefore, my lord, to the extent of saying by railway now that you can quote higher, but you cannot quote below. So higher is a hidden criteria. Now you have settled this contract by applying a hidden criteria, therefore it's vicious. My lord, when we talk of transparency, transparency must be to the hill. That, my lord, that West Bengal State Electricity Board's case, to Patel Engineering versus West Bengal Para 21, 2001, where the Supreme Court clearly said, only way to ensure transparency is to follow the tender conditions. Tender condition says at par, only what is missing. But we have to, well, as an employer, they should have given that meaning. Instead of taking this route, circuitous route of defending an unauthorized illegal action, my lord, they should have come up with a contrary clause. This tender cannot, supposing, my lord, tomorrow the respondent number 4 case is rejected and he files a writ petition, what stand would railway take? Let us test it from the reverse side. Tomorrow respondent number tender is rejected, saying no, you are L2, not L1. This component cannot be agreed because you have not quoted at par. Then railway, what stand railway will take, my lord? End of the day, my lord, it has to stand to some logic. Therefore, my humble submission is, my lord, it's a hidden criteria to the extent of allowing a higher bid, a rate which is higher than the at par rate. So therefore, my lord, this process has vitiated. Matters should be sent back, my lord, they should reconsider. And, my lord, I have brought 2-3 judgments. My lord, these are all well known, my lord.
Which one are you referring to?
My lord, first I'll be relying on our High Court judgment, my lord.
Which one?
My lord, that Muhammad Makroob Khan versus Manoj Kumar Sharma. Para 12. Para 12, 13 and 15. Since you are relying on a clause that higher is permitted, lower is not permitted, you must disclose it. That is the, my lord, legal position which is obtaining. Para 12 at page 20. Has the lordship got it? A reading of the aforesaid observation of the apex court would indicate that out of the 3 grounds mentioned, rendering acceptance of the tender unsustainable, grounds number 1 and 2 are imperative and must be followed in every tender process. An omission to follow the law laid down in ground number 1 and 2 will vitiate acceptance of the tender. Logically, therefore, it would follow that every NIT must disclose the procedure which should be followed in the matter of acceptance or rejection of tender, so that entire tender process becomes transparent, fair and open. So what prevented the railway, as was done in the other 3 tenders which we have placed, my lord, from saying at par means at par? Higher, lower, no business. We take the aforesaid view from the following observations made in the case of Dr. Associates. We reiterate that whatever procedure the government proposes to follow in accepting the tender must be clearly stated in the tender notice. The consideration of the tenders received and procedure to be followed in the matter of acceptance of a tender would be transparent, fair, and open. While a bona fide error or error of judgment would not certainly matter, any abuse of power for extraneous reason, it is obvious would expose the authorities concerned, whether it is a minister for excise or commissioner of excise, to appropriate penalties at the hands of the courts. Following the law laid down by this court in Sips Sagar Tiwari and Satish Sharma. In the present case, there is no dispute that NIT did not contain any condition that authorities would consider the viability or suitability of the tenderer in accepting the tender for settlement. Further, it would appear that only after opening of the tender, in the comparative statement of the tender, it was commented that the bid of the writ petitioner respondent is exorbitant and speculative and found to be more than 75% of the last year's bid. Materials on record also do not demonstrate that any prior decision before opening of the tender was taken with regard to what, according to the board, is viable and suitable rate. We express no opinion as to whether such a code would have been permissible or not. As such, an issue has not fallen for our consideration while deciding a present appeal. Now, this is important. Permitting to adopt a hidden criteria in the matter of settlement of contract is fraught with grave danger and same is an anathema to the concept of transparency, openness, fairness, which had to be scrupulously observed in the matter of distribution of state largesse. And Dr. Associates Miller is already quoted. Another one coordinate bench judgment, Miller, that Hasmot Ali, 2022 6 GLR, page 68, paragraph 19.
Where is the judgment?
Yes.
Yes. We have.
Para 19 at page 81, Miller.
2022 6 GLR.
Para 19. Yes, at page 81. Towards the bottom of the page, after Placidum H. The bidders participating in a competitive bidding process have no other right except right to equality and fair treatment in the matter of evaluation of the competitive bids offered by them in response to the concerned notice inviting tender in a transparent and non-discriminatory manner and free from hidden agenda. At the same time, the procedure to be adopted in a competitive bidding process by the state or its agencies, which is for distribution of state largesse in one form or the other, must have to be fair, transparent, and rational, providing equal opportunity to all interested and eligible persons to participate in the process. The decision of the tendering authority in the matter of evaluation of bid or in awarding a contract must not be arbitrary, irrational, and unreasonable. If the matter of evaluation of bid or in awarding a contract has to conform to any statutory prescription, then the tendering authority must be alive to such statutory prescriptions while evaluating the bids or while awarding the contract, which is in the nature of distribution of state largesse. The decision-making process of the state or any agency, instrumentality of the state, in evaluating bids or in awarding contract is required to keep the possibility of discrimination, arbitrariness, and favoritism out of the purview, and same should be transparent, fair, bona fide, and in public interest. The power of judicial review in respect of matter relating to award of tender is for the purpose of checking arbitrariness, irrationality, unreasonableness, and bias. It is intended to check whether choice or decision is made lawfully and not to check whether choice or decision is sound. Though in the matter of awarding contract by the state or any of its agencies, instrumentalities, price is one of the relevant criteria, but price is not the sole and decisive criteria. Maintenance of sanctity of a competitive bidding process on the aspect of fairness, transparency, and definiteness and providing an equal level playing field cannot be compromised with the acceptance of a bid which is otherwise not valid, being non-compliant to the terms and conditions of the tender notice and was deficient at the time of the submission. So, my lord, what follows from all these authorities is very simple, my lord. In the process of finalization of a tender, fairness has to be ensured. And how fairness can be ensured, my lord? By bringing in objectivity in the tendering clauses. Now, what prevented the railway in the instant case, as was done in the other three cases, from clearly coming out with the stipulation that until and unless it is at par, it will not be accepted. So therefore, my humble submission is, my lord, it's a clear case where some legroom was left for the authorities to, my lord, apply at the time of finalization of the contract, which under the law in force is not permissible. Otherwise, my lord, there will be, my lord, no way one can check arbitrariness or favoritism. Now, question is whether you did it or not, that prejudice I did not plead. The moment is a violation of fundamental right. It is presumed, my lord, that there is a violation. Therefore, to obviate all these things, you should clearly come out with the conditions which you will apply in settling a tender. Once you do not come up with, you cannot apply. That higher is not there, therefore you cannot apply. So it has to be construed as at par. And, my lord, what is difficult in appreciating that meaning as an employer, my lord? As I have already said, supposing tomorrow if the respondent number 4's tender would have been rejected on this ground and he would have laid a challenge, what stand railways would have taken, my lord? So therefore, my lord, it's a clear-cut case of.
What about the aspect of free play in the joints?
Exactly. No. Free play in the
To what
joints
extent
is a
you-
necessary concomitant, as Supreme Court said
Yes.
that this decision.
Fascist Chaudhary.
Ah,
Doordarshan case.
Doordarshan case. No, my lord, that is a different, it's a question
No,
of,
but
my
to
lord,
what extent free play in joint can be?
free play in joint cannot violate Article 14. Free play in the joint is a concept, my lord, that has to be considered to the authority in an appropriate case. Supposing, my lord, a view is taken which is otherwise rational, but maybe there is some non-conformity here or there. But it is not so irrational, it is not so arbitrary, it is not so biased. Now here, my lord, they are applying a criteria which they have not indicated in the tender, whether this can be permitted. End of the day, my lord, we are not on the decision, correctness of the decision, we are in the correctness of the decision-making process by applying a criteria which you have not clearly stipulated in the NIT. That is our case.
Yes, Mr.
The outset, my lord, I'd like to submit that the challenge, my lord, which is here before lordship is not as to the manner in which the evaluation of the bid has been done. That is not on the challenge.
But that is what will be, that is what we'll be examining.
No, yes, man, I'm coming to it now.
We'll examine
I'm
only
coming
that
to it,
part.
Exactly.
Hmm.
The manner.
More
of
than the decision, we are on the
manner
decision-making
of
process.
decision by which the petitioner has been declared to be not L1, that is not under challenge. The conditions of tender conditions are put to challenge, my lord, after participating in the tender process and after failing to secure the successful bid. Here, my lord, it is a challenge to the tender condition. Now the question of maintainability comes here, my lord, whether a tender condition can be challenged after participating in the tender process. Because this condition applies to all bidders, not to the petitioner only, my lord. Today, my lord, to participate fully and after the finalization of the tender.
Let us see,
challenge that tender.
no, let us
condition.
examine your contention.
Yes.
Let us see the prayer.
Yes.
What are the prayers?
The prayer is, my lord, the
Page
PROCEEDINGS
17.
shall not be issued for setting aside the impugned decision of the respondent authority to arbitrarily settle the award tendered works in tender to respond number 4 as L1 bidder despite the fact that its bid is in violation of mandatory clause condition.
Yes.
So therefore, the clause is.
Mr. Gupta, before making a submission, you are sufficiently senior in the bar. Don't make submission on the air.
No, my lord.
We don't like this. Have you read the prayer before you making the submission? Which condition has been put to challenge?
Clause 12, my lord.
Condition is put to challenge. This is how I understand English language. We're very sorry.
Well, in other words. my
What
lord,
in other words? You're trying to build up a case without even reading the pleadings? Make submissions which are reasonable, will accommodate you, but not this kind of submission.
Because, my lord,
That
in
some
my-
condition has been challenged or participating, as if to influence the court to take a decision on some other side. Where is the challenge to the condition?
Coming to the point, my lord.
No, please be fair to the court. If you have not prepared the brief, prepare the brief, we'll grant you time.
Come to the point, my lord.
So what is the first submission? That some condition has been challenged.
Because,
We
my
have
lord,
seen the
tender
prayer.
conditions
Let
are
us read the
very-
prayer again.
My lord, the tender conditions are very clear. In that context.
So is it the submission, is some condition has been put to challenge? After participating, you say that this condition is bad, so set aside that condition. Is that your case?
In a way, my lord, the
You're
petitioner
insisting on that.
But if I may take, my lord, to page 117.
You're insisting on that. Please show us which condition is put to challenge.
My lord, but the petitioner is trying to, my lord, put a condition which is apparently not there in the tender condition. That is what my humble submission.
That is a entirely different submission. That is
what
an
I-
entirely different submission.
My lord, I wanted
First
to-
submission is a different
My
submission.
lord, I wanted to convey that way.
No, you do not wanted to convey.
My lord,
You wanted to convey something else which you all also understood properly.
my lord.
Don't do this.
Maybe not, I have.
Don't be unfair to the court.
My lord.
We also read the brief. We cannot go by your submission.
My lord, the tender conditions are very clear, my lord, in my humble submission. At page
Make your submission. What are
117,
your submission?
There is, my lord, the requirement of submitting the bid is very clearly mentioned that it should be, my lord, below par. It should not be,
Below par.
it should be at par, my lord.
Which page?
Page 117.
117 is come.
Paragraph 12, 13 and 14 I will read, my lord.
Yes.
The bonus at 8.33 of the minimum wages, which is admissible as per the bonus act, made by the contractor for coach mitra staff supervisors shall be reimbursed to the contractor only after submission of the proof that it has been credited to their accounts, subject to eligibility of the staff for payment of bonus as per the prevailing bonus act. Now, my lord, this requirement is as per the bonus act, my lord, that minimum 8.3.3 should be the bonus. That is why that requirement of at par was, my lord, given that we have stated in the affidavit also. Subject to, bidder should quote at par against item number 1 of schedule 2, schedule 2 of the rate schedule.
Even again, you are making a wrong submission.
My lord.
At par, you are bringing it to 8.33. Again, a wrong submission you are making. Why do you make wrong submissions? What do you gain?
My lord.
You place everything fairly to the court.
No, the 8.33 is what is there, my lord. That is
At
the-
par of what?
of the
Of the schedule rate.
schedule rate.
What is the schedule rate?
The amount is, my lord, 1 crore, my lord, 34 lakhs 98,500.
So at par with schedule rate, you can make a submission. That at par may also include something more, which will not be adversarial to the workers. That we can make.
My
That we can consider.
my lord.
It's clear. You have written in bold.
Bidder should quote at
It's
par
written in bold.
against item. number
Bidder
1.
should quote at par against the item number 1 of schedule 2.
My lord.
What is item 1 of schedule 2?
That is, my lord, provision for payment of bonus to staff.
Item 1 of schedule 2, let us see. Provision of payment, the amount has been quoted. 13498 565.61.
Yes.
Whether it is 8.33 or 8.44, we are not too much concerned. You have quantified the figure.
My lord.
And in bold you have written, bidder should quote at par against item number 1 of schedule 2 of the rate schedule. Quoting below par against the bonus
Yes,
item will lead summarily rejection of their offer.
Quoting
On-
below par is, my lord, what
On the
is-
last occasion, we remember you saying that only below par would be a summary rejection.
So, my lord,
Higher
this-
quoting may not be. That is the submission. That we can consider. That's
that
not a
is, my
problem.
lord. So, my lord, the submission which now have been advanced is that the higher quoting by the L1 is contrary to the tender conditions. That is prima facie not correct, my lord, because the tender conditions have to be interpreted as it is. it cannot be given a different meaning, my lord, unless there is an ambiguity in the plain reading of it. And the plain reading of it is very clear, my lord, that if the quoted rate, including rebate percentage against schedule 2, is below par, only then it will lead to rejection. Therefore, my lord, the petitioner is not on their own evaluation that the authorities have done the evaluation of financial bid wrongly. Rather, they are on the qualification of L1 who has been wrongly selected.
You
By
mean to
saying
say that there is no bar to quote above par?
there is no bar to quote above par. And if that condition is, my lord, expressly not given in the tender condition, can it be put forth by way of own interpretation? Because it is the authorities, my lord, who are to decide. Unless, my lord, it shows some malifiedness or it is without any reason. Now here, my lord, 8.33 is under the act, my lord, that I have stated in my affidavit also, that the minimum percentage of bonus should be 8.33 in paragraph 12 of my affidavit. Paragraph 12, page 162. Clause B. As per Bonus Act 1965, clause 10 for payment of minimum bonus, every employer shall be bound to pay to every employee in respect of the accounting year commencing on any day in the year 1979 and in respect of every subsequent accounting year, a minimum bonus which shall be 8.33% of the salary or the wage earned by the employee during the accounting year. So that was the requirement which has been put forward, my lord. Now the requirement that if someone quotes higher, that will lead to rejection is apparently not there. Also, in view of the fact, my lord, that it is not only the petitioner, there was L8 also, my lord, page 154. He also quoted, my lord, higher. L8, my lord. The other bidder, my lord, the conditions are equal for all.
Where 154, which one?
My lord, 150.
No, all have quoted.
155, my lord. My lord, we'll take 154 first, my lord. Where the bottom enters a rank L8 is given, my lord, SMC Integrated Facility Management Solution Limited. Now, this is, my lord, schedule 1. Next page, my lord, schedule 2. And at the top, my lord, we see 4.69 in schedule 2, my lord, 4.69, the last table. 4.69 above.
No, he did not ask. That is not.
That is L8, my lord.
That is L8.
So-
L8. That is L8, not.
So, my lord, it's not that, my lord, quoting above par will lead to the rejection of the bid itself. That was not the, otherwise, my lord, L8 would have rejected at the threshold itself.
Now, how is it connected to his case? You don't reject somebody else's. How is it connected? He has come before the court. We're examining
To
his.
say that, my lord, the L1 has been wrongly selected. To clarify that, my lord. it
If
is
you
not
had selected L8, they would have made L8 a party here. How does L8 comes
This is
in?
the requirement of quoting a higher rate. He
No.
has also quoted a higher rate.
Now, will putting to challenge L8's qualification, will they gain anything? Nobody has got such an amount of time or money to come to the court to make a declaration which will not yield nothing.
No, this is regarding the requirement of, my lord, quoting a higher rate.
How is he coming to play L8?
Because he has, I am trying to submit, my lord, he has quoted as per the tender conditions. Only 4.69. He has quoted as per the terms.
Wholly irrelevant, Mr.
No, no.
Gupta. In the present challenge, he confined to the present challenge. Somebody has quoted something else. He's not in the fray, not made a party. How are he connected?
My lord,
You select him, we'll see, we'll put him in the loop and
I
have.
want to submit, my lord, that quoting above rate will not lead to.
That you have
has not
submitted.
led
That
to the rejection of the bid.
we are considering that.
That is what I am saying.
That we are
And
considering.
has also been considered for financial evaluation, my lord, after his bid been successful. Otherwise, at the threshold, he would have been rejected. So I am trying to say, my lord, that this condition is applied to L8 also. He has also quoted a higher rate, my lord, following this condition only. And his bid was considered for evaluation. Otherwise, my lord, if the tender condition would, the requirement of the tender condition would have been, my lord,
So
that
if you do a wrong, so you can have that precedent.
that, my lord,
Somebody
to
has done
decide once
this.
I have
I will also do this. He may be wrong, but he has done this.
Lord, I am submitting that there has been no wrong. That
Now
remains
that's a different
standing.
submission.
They
You
have
cannot
not-
justify because we have taken for elite also we are correct. You have to be correct on the stand by countering the contents of the petitioner.
Well, so my humble submission is, Lord, the tender conditions are very, very clear. It does not, nowhere it prescribes that, my lord, if someone quotes above par, it will lead to rejection of the bid. There is no, my lord, malafidness, there is no unreasonableness on the part of the authorities, my lord, or to favor anyone. And the calculations which we have done.
Mr. Gupta, you show us where is the provision for giving rebate?
Yes, my lord. That is
Page?
clause 13, my lord.
Page
Page 117.
117. Okay, let us see. 13.
13. Clause 13, my lord, page 117. In case of,
Yes, in case of.
my lord, any rebate offered by the bidder over the gross quoted value.
This is the only criteria. Anywhere else, anything on rebate. This we have seen. Rate offered by the bidder over gross quoted will be examined.
Regarding rebate, my lord, that is only the criteria.
In such case, it won't.
Okay. And my lord, one more thing is to just like to point out, my lord, at page 119,
119.
the 19,
Yes.
the column rates, my lord, 4.1. There is mention in the tender condition that, my lord, contractor should quote at par, percentage at par, above par, below rates on the schedule. And thereafter, my lord, these conditions come under the heading, my lord, important note. Therefore, my lord, the tendering authorities have done it with a very clear intention of mind, my lord, that it is only below par which will lead to the summary rejection of the bid. There is no question of, my lord, putting above par which will lead to the rejection.
How is this 4.1 connected?
Yes.
This is with regard to rates.
But with regard to the rates, how the tenderer will quote. My lord, it says, my lord, he can quote at par, above or below.
Yes.
But that is subject to, my lord, this condition at clause number 12.
Now, this is only with regard to the percentage. How you quote? You quote a percentage above at par. It can be percentage below par or above par. It's in the. It has to be in the.
My lord.
On the basis of percentage.
Yes. On the schedule, it is written, my lord, should quote at par, above, below rates on the schedule.
Yes.
Now, my lord, it has to be read with, my lord, page 117, clause 12, clause 13. And it overrides that requirement, my lord, and only below par is treated to be the ground for summary rejection. Very specifically, had this clause been not been there, my lord, otherwise he can quote above par also. So very clearly, my lord, it is only below par which has been made as a ground for rejection in view of in terms of the payment of bonus act. And now this condition, my lord, is very clear. Now this condition cannot be interpreted, my lord, in a different way by incorporating another line, my lord, saying that above par is liable to rejection.
Okay.
And my lord, in the minutes of noting which I have submitted, my lord, there is an explanation also with regard to, my lord, this bonus item, how they have applied it. Page 14, my lord, in handwritten minutes of the tender.
Page.
Page 14, my lord.
14.
Yes, my lord.
Discussion.
Discussion on compliance to bonus items.
Yes.
Here also, my lord, in terms of the tender condition, authorities have discussed how they have applied.
Hmm.
As per note number 12, at page 92 of schedule of rates, it is mentioned that the bonus at 8.33 of minimum wages, whichever is admissible as per the bonus act, made by the contractor for post mitra, staff supervisor, etc., shall be reimbursed to the contractor only after submission of the proof that it has been credited to their account subject to eligibility of the staff for payment of bonus as per the prevailing bonus act. Bidder should quote at par against item number 1 of schedule 2 rates. Quoting below par against the item will lead to summary rejection of their offer. Now, it will lead to summary rejection of their offer, my lord. That is why I was submitting, my lord.
No, this is same as 117.
The same as
Same.
117.
What is different here?
This is the manuals of the tender committee.
Yes,
The
as
tender
per note 12. Note 12 has been quoted here.
Yes. Further, my lord, further I will read, my lord.
As per note
As per
13,
note
it has been
13,
quoted.
That is there. Now, the third paragraph, my lord, in the tender, the provision for bonus is made in the tender is lump sum, which will be reimbursed to the contractor only after submission of proof that it has been credited to their account subject to eligibility of staff for payment of bonus as per prevailing act.
Yes.
Now, my lord, as per bonus act 1965 section 11, payment of maximum bonus permits the allocable bonus surplus exceeds the amount of minimum bonus subject to maximum ceiling of 20% of salary or wage. The said provision has also been reiterated by Regional Level Commissioner letter dated so and so. Thus, the critical threshold for rejection under the bonus criteria shall be any financial bid submitted by a firm quoting below the bonus prescribed in the tender, that is below par or below 134.98,565. That's it, my lord. So where is the question of quoting above par? How they are prejudiced, my lord, if they quote above, if they are allowed to permit quote above par? In fact, they are not questioning that. In fact, they are questioning why L1 has been selected, my lord, quoting above par, whereas there is no condition to that effect. Apparently, my lord, it cannot be. There are no two meanings, my lord, which can be discerned, my lord, from apparent reading of the clause. And how they are prejudiced, my lord, if the L1 is selected by quoting above par, how they are prejudiced, how their rates would, my lord, affected. Their rates ultimately, my lord, after quoting the rebate, they are still, my lord, L2. If, my lord, rebate is applied to all the schedule of items, my lord will see, the L1 remains L1. There is no difference to that. So the challenge, my lord, becomes mere academic. Otherwise, my lord, all the things remains the same. My lord, in support of my contention, my lord, regarding the tender conditions, what I have given the list of citations, my lord.
No, before you go to the citation, see, you have to understand their case. It's not a question of R4 being the L1. First, they are questioning that there is a violation of this condition, which you are trying to defend, that the threshold rejection would only be when you quote below par. There is no restriction of above par. That is your answer. Number two, the ultimate price after the rebate which has been quoted by R4 appears to be less than them, but the price component as such was above them. If you leave, if you that obviously total. If you segregate the bonus component, the price quoted by R4 is higher than the price quoted by the petitioner. The challenge is on the ground that on the bonus component you have violated the schedule and the rebate is given or gross. Ultimately, the price becomes lower than the petitioner.
No, my lord, that is what I was submitting. Well, again, that amounts to challenging the tender conditions because, my lord, the clause they have quoted above par and all, but their bids were, my lord, evaluated. So far as
that is what they are trying to say that it should have been rejected at the threshold.
No, after participation in the tender process, can they challenge, my lord? That is the question, my lord.
They are not challenging. They are only trying to.
My lord, they are not
They are
challenging, my
only
lord.
trying to
sorry,
have it complied. You are not complying with the order of.
They are not challenging, they are trying to question that clause.
Not questioning.
Interpreting the clause, my lord.
Interpret whatever interpretation may be wrong, but they say that there is a clause which requires a bonus to be given in a particular manner. That manner has not been prescribed, not been followed by R4, so reject R4.
Yes. Yes. Whether, my lord, that.
And what about the other two tenders where your criteria appears to be something different?
Those are
Three
different
tenders.
tender conditions, my lord.
Hmm?
Those are completely different tender conditions. Whether, my lord, will go into those tender conditions. These tender conditions are very apparently clear, my lord.
No, you are the same organization.
Indian
These are only for evaluating the price bids, and bonus is involved there.
Those
We are not on
different,
the
my lord.
we are not on the description of the works. It may be for different works. It may be for some housekeeping. That may be for construction.
They are different tender process, my lord, different tender conditions. The authorities may put those conditions, my lord. And this is a different tender conditions. And my lord, in my humble submission, I am asking myself what prejudice is caused to them.
Prejudice to have a fair competition in facing a fair
Yes,
competition.
They will still remain L1, my lord. They have not quoted the rebate 0.80. They have not quoted rebate. The overall, my lord, the rate quoted by them is below the L1, my lord.
And that is why we are asking where is the 13, your answer 117, 13 is not the answer to the question.
No.
We are asking where is the provision to give a rebate?
That is there, my lord, at page 117.
One is in case any rebate offered, where is the provision?
My lord, provision is, my lord, it is an online bidding system. The, my lord, one sheet I had given, my lord, in check. Is where.
Which sheet? One more sheet you have given, this one.
Yes, yes, my lord, that's it. Yes, my lord. That reflects, my lord, this is an online.
No, it is their document.
Yes, my lord.
No. Now, where is the provision to give such a rebate? Just trying to have it from you.
Provision, my lord, provision in my humble submission clause says so, my lord, that rebate can be given. The manner of giving is it is in the online portal.
13 is not enabling provision.
Evaluating.
13 is not an enabling provision. We have to
It
see
is a
where.
system, my lord. It's an online system.
No. Where do you get it?
No, it's when the bid is submitted online, my lord, it is technically this printout.
We are not on the aspect of giving rebate. From where do you get that a person, a bidder, is also has a scope to give rebate?
This is under the law, my lord, or
Tender clause.
under the tender.
Tender clause, we are asking.
Tender clause is there also. This
Which
page
one?
117.
Now, in case a rebate is given, it presupposes that there is a scope to give rebate.
Yes.
Where is that? See, normally what we understand, price bids are very sacrosanct. And even if you want to negotiate, there has to be a negotiation with all. Normally, you can still have a better price. You are the owner. But you should give such a scope to all the eligible bidders.
Yes.
But here,
they have not quoted at all. They have the option to quote 0.80. They have not quoted.
the answer is not
Maybe
coming
they
if you
have
do
not
not show the
defined
scope.
conditions properly, my lord.
Now, if you do not show the scope, under what scope, what provision rebate can be offered?
That is 13, my lord, reading of clause 13, my lord, that which is inbuilt. Although that separate clause, my lord, I am not able to point it out. But clause 13 says, my lord, that in case any rebate is offered.
That the party can give rebate, there was the enabling provision, which is that court is asking.
Provision to play nine.
one nine.
You said that the other contracts are different contracts. So conditions may not be
Malo,
the same.
malo, malo. And here what I have been informed that in the portal, the option is there, malo. They can see, the bidders can see that there is a, although in the clause, malo, it is not there, but while submitting the online bid, that option is there, and then they can confirm after whether they have given, they really want to give rebate or not. That option is there. Although that specific clause which my lord is pointing out, that is not there. But the online system, it is there. That we have taken the affidavit also. Ample submission, my lord, there is no ambiguity in the clause, my lord, and there is no malifiedness on the part of the person. My lord. And two citations, my lord, I would just like to rely, my lord. At 2022 6 SCC 1, I've given the list of citations, my lord. NG Projects Limited versus Vinod Kumar Jain. Paragraph 17. Paragraph 17, my lord. Therefore, the position of law with regard to interpretation of the terms of contract is that the question as to whether a term of the contract is essential or not is to be viewed from the perspective of the employer and by the employer. Applying the opposite position of law to the present case, it has been the contention of the respondent that the format of the bank guarantee was not followed strictly by the state, and that relaxation was given was not uniform in respondent number 1 was singled out. The said contention has found favor with the courts below. Then, my lord, paragraph 22.
Yes.
The satisfaction whether a bidder satisfies the tender condition is primarily upon the authority inviting the bids. Such authority is aware of expectations from the tenders while evaluating the consequences of non-performance. In tender in question, there were 15 bidders. Bids of 13 tenders were found to be unresponsive, that is not satisfying the tender conditions. The writ petitioner was one of them. It is not a case of the writ petitioner that the action of the technical evaluation committee was actuated by extraneous considerations or malifiedness. Therefore, on the same set of facts, different conclusions can be arrived at in a bona fide manner by the technical evaluation committee. And I'm skipping this one. Paragraph 23. In view of the above judgment of this court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of the tender. The court does not have the expertise to examine the terms and conditions of the present day economic activities of the state, and this limitation should be kept in view. Court should be even more reluctant in interfering with the contract involving technical issues, as there is a requirement of necessary expertise to adjudicate upon such issues. The approach of the court should not be to find fault with magnifying glass in its hand. Rather, the court should examine as to whether the decision-making process is after complying with the procedure contemplated by the tender condition.
Exactly.
If the court finds that there is a total arbitrariness or the tender has been granted in a malified manner, still the court should refrain from interfering in the grant of tender, but instead relegate the parties to seek their damages for wrongful exclusion rather than to injunct the execution of the contract. The injunction or interference in the tender leads to additional costs on the state and is also against public interest. Therefore, the state and its citizens suffer twice. Firstly, by paying the escalating cost. Secondly, by being deprived of the infrastructure which the
These observations are not relevant. These are connection with 41H of the specific relief act,
Yes.
where infrastructure projects were directed, there should not be any stay order.
And my lord, in Jayad Bholenath's case.
It has been clarified, Jai Bholanath.
This is the tender regarding the tender conditions, my lord. Here also the although the bid of L1 has been found to be technically responsive in view of the same clause 13, my lord, which says the requirement of which is only that below par would be liable to rejection, and then bid was accordingly evaluated. Now, my lord, that same clause has been, my lord, has been interpreted to be against, my lord, the petitioner, and that's why they have approached this honorable court. Now, my lord, coming to 2016, my lord, 16 SCC 818, Afcons Infrastructure Limited.
2016,
16 SCC 818.
Afcon.
Afcons, my lord. Paragraph 11 to 15.
The employer would be the best judge to
Yes, my lord. Mere
interpret the tender conditions.
Yes, my lord. Mere disagreement with the decision-making process or the decision of the administrative authority is no reason for a constitutional court to interfere. The threshold of Malafide's intention to favor someone or arbitrariness, irrationality or perversity must be met before the constitutional court interferes with the decision-making process or the decision. And my lord, paragraph 15 is important, my lord.
Yes.
We may add that the owner or the employer of a project, having authored the tender documents, is the best person to understand and appreciate its requirement and interpret.
That is what we have said, will be the best judge to interpret.
Then, my lord, the 2026 4 SCC 310, my lord. Prakash Asphaltings and Toll Highways Limited. Para 39.
310. Prakash. Para?
Para 39, my lord, wherein, my lord, Jagdish Mandal was quoted, my lord.
Okay.
In judgment.
Hmm.
My lord. And, my lord, before interfering in contractual matter, my lord, Supreme Court has, my lord, that following question should be examined, my lord, whether the process adopted or decision made by the authority is malified or intended to favor someone, or whether the process adopted or decision.
Yes, those are well known.
And, my lord, one more is judgment, my lord, is 2022 SCC online SC 1334.
Shilpi.
My lord, Airport Authority of India versus Center for Civil Aviation.
Which is this? I'm not sure. 2022.
Paragraph 14, my lord.
Paragraph?
Paragraph 26, my lord. Paragraph 27, my lord. Even otherwise, even on merits, the High Court has erred in quashing and setting aside the eligibility criteria, tender conditions mentioned in the respective RFPs while exercising the power under Article 2 of the Constitution. As per the settled position of law, the terms and conditions of invitation to tender are within the domain of the tenderer, tender making authority, and are not open to judicial scrutiny unless they are arbitrary, discriminatory, or malafide. And my lord, clause 30.
Which paragraph did you read right now? 26,
27.
27. Okay.
And my lord, clause 30, paragraph 30, clause C.
Same airport authority.
Yes, my lord, C, airport authority.
In the matter.
In the matter of formulating indifference of a tender document and awarding a contract.
This is a quotation from Michigan.
Yes.
Michigan rubber.
Michigan rubber. Lord, in my advice submission, my lord, there is no ambiguity in the tender condition.
You say that greater latitude should be given to the authorities.
Yes.
This is Michigan.
That is well.
Okay. What is your name, madam? Your name? No, your name. Here for R4. Yes.
Logic. Page 114 logic. This is the
Page?
page 114, which is already discussed.
Yes.
So this is the schedule of trade. And 117 logic, where the conditions were laid down. Logic.
Yes.
So logic, I also want to read this 12, 13 and 14. The bonus at the rate 8.33% of minimum wages, whichever is admissible as per bonus act, made by the contractor for coach mitra staff, supervisors, etc., shall be reimbursed to the contractor only after submission of proof that it has been credited to their account subject to eligibility of the staff for payment of bonus as per prevailing bonus act. Bidder should quote as per against the item number 1 of schedule 2 of the rate schedule. Quoting below par against the bonus item will lead to summary rejection of their offer. So, Lordship, this is e-telephone. Lordship, when we submit our bid through e-portal, then Lordship, there's some columns where it was also there. Rebate provision, Lordship, in the e-portal system. So, there we given 0.81% rebate, Lordship. I have given a sheet to the Lordship. This is auto-generated copy, and I have kept it with me at the time of bid, Lordship. So, this is the provision, Lordship, here we have received, and accordingly we have given 0.81% rebate. This is at par. Now, Lordship, when we go to point number 13 of the condition, in case of any rebate offered by the bidder of a gross quoted value, each individual item will be examined considering rebate percentage. So we have given rebate on gross value. And in such case, if quoted value including rebate percentage against schedule number 2 of BOQ, that is provision of bonus, is below par, then the offer will be summarily rejected. So, Lordship, if we give 8.33% rebate at par, and if we give the rebate on the gross value, then automatically we will be below par, Lordship. So, which is a reason for rejection of my bid, Lordship. So, Lordship, I have given arithmetic calculation form. I have tried to make an arithmetic equation of the
I think I've given this.
Yeah.
Just a minute.
So, say if
Just a minute. You can explain this to us. Main point is. Where is it?
this lordship in the area 7.
7.
As per NIT, the bonus is as per that is rupees, that is 8.33% amount of rupees 1349856.61. The respondent number 4, that is me, has quoted 1360790.3.99, that is above 0.81. As per calculation, the rebate 0.81%, then lordship it will be 497679.96. It will be below at par. Because the rebate is upon the gross value. So if we not given that that rebate, then lordship our bonus item will be below par lordship. So which will be a reason for the rejection of my bid lordship. And Fairness Legal Council stated that there is a hidden criteria. Lordship, as I understand from the point 13, this is clear lordship. In case of any rebate offered by the bidder over gross quoted value, each individual item will be examined considering rebate percentage. In such case, if quoted value including rebate percentage against here, if quoted value including rebate percentage against schedule number 2, that is the bonus, is below par, then their offer will be summarily rejected. Then I'll be rejected lordship if I want to give rebate. There is no any, as per my understanding, there is no hidden criteria. It is very clear. Is below par, then my bid will be rejected, lordship. Because online portal we have received that provision for rebate. And that rebate is given at the time of submitting the bid, not after opening of the bid lordship.
Yes.
Yes, lordship. So I want to say that the rebate is given at the time of submitting the bid, not after the opening of the bid. And that is from my sheet lordship. It is very clear that when I have submitted through e-portal, that time I have given my rebate on gross value lordship. This is my humble submission, lordship. In the comparative statement, it is also seen that they have quoted 0.00, not nil lordship. The rebate is 0.00 in the comparative statement. That is not written as nil or whatever. They have the amount that is 0.00.
What would be the difference between 0.00 and nil? There's no difference.
যদি সাবস্ট্যান্টিভ প্রভিশন পাঠালে এগুলো থাকলে হবে না।
That would be not applicable.
এই পোর্টালত বাই ডিফল্ট is 1%. By default है।
Yes.
Lord, I'll give a short reply, my lord. Now, my lord, my friend Mr. Gupta, his entire argument is fallacious. My lord, he started his argument by saying, we having participated in the tender process, how come we have challenged it? Well, this is neither here nor there. My lord. We have not challenged any clause. All that we have said is that here is a case, you have evaluated the financial bid by adopting a criteria which you have not spelled out in the tender condition. Now, my lord, my argument has been supported by him by referring to page 119. Please come to page 119, my lord, the rates. Kindly see, my lord.
119.
Yes. I am obliged to my learned friend for pointing out. I do not know how we missed it. Rates towards the bottom of the page. Contractor should quote percentage at par, above, below. So this nullifies his first argument that there is no bar that higher can be permissible. But this is the only substantive provision regarding rates. My lord, in e-portal normally many provisions comes by default. And Lordship has posed a very relevant question. Where is the substantive provision which specifies that a bidder can give rebate? My lord, by default many GM portal, my lord, by default many provision comes. Ultimately, this is the provision which governs how rates should be quoted. So it says, my lord, now we have to take which page? Page 117 or 119? If somebody can quote at par, below, above, then how come by clause 30, para 13 at page 117, you are restricting that? So that is why, my lord, what is required is, whatever the conditions which you want to follow, you must spell it out. So that tomorrow situation like the present one with which we are confronted is obviated. Rates for the item of schedule shall be inclusive of all costs. Rates quoted by contractor shall be cost completed. Everything will. So regarding rate, only conditions in the tender is this, clause 4.1. (4.5) Contractor should comply to the statutory wages like etc., etc., etc. So, my lord, there is no other provision regarding rate. So, my lord, there is no substantive provision. Because provision of rate does not include that there could be a provision for giving rebate. That is one way of looking at it. Now, my lord, I still stand by my first submission, my lord. Here is a case to the extent of saying that one can quote higher, not lower. That is a hidden criterion. And you must spell it out, which you have not done it. Now, kindly see, my lord, at page 146, we have already indicated the respondent number 4's quote qua PF is above par. Above par is not at par. Page 146. In our representation, which we indicated, my lord, kindly see provision of bonus to staff at par is the first column. So L1 is quoted 136. So from here, if we minus 0.80, it becomes 1 crore 34,000 lakhs 99,000. That means 1 lakh 1,000 something is more, my lord.
Yes.
So it is not at par. So breach of, now please come to page 1117 for a moment, my lord. Eventually, my lord, what it says, apart from the highlighted portion, please come to 14. Last 3 sentence. Thus, provision for bonus for all category of staff has been incorporated in the tender, whereas payment to be made on actual basis as per feasibility of payment as per Bonus Act. Bidders are advised to quote at par against bonus item will all possibilities for ensuring smooth compliance of the Act. So, my lord, by giving rebate, the price of respondent number 4 has become more than, my lord, what is stipulated in the tender. So there are two infirmities, my lord. One, you have not indicated the higher part, and secondly, the rate which has been offered by respondent number 4 post, my lord, evaluation, it has come to 1,000 rupees more than the par, but it is not at par. Now, on this ground, my lord, his tender should have been rejected, in which case I would have become L1. That is the infirmity. That is the flaw in the decision-making process.
But Mr. Chaudhary, what about 13
Yes, my lord.
at 117?
No, but that's why I said, my lord, assuming it is correct, then to the extent of saying that you can quote higher is a hidden criteria. When other tenders of the same Indian Railway says at par means at par, what prevented them from saying here, my lord? If we take preponderance of, my lord, meaning of all these three clauses, what is clearly evident is, what is emphasized is, it must be at par. My lord, employers' understanding of a tender clause has to be given due deference by the Honorable Court, Constitutional Court, as has been, given, held by the Supreme Court in so many cases. I am not on that, my lord. But, my lord, in the name of giving due deference, a black cannot become white, a white cannot become black. Otherwise, my lord, Article 14 will lose all its relevance. Let us be very clear about one thing. Otherwise, then Supreme Court should say that High Court should stop taking up to 26 petitions. Because if in NJ Export says, even if there is, you go to civil court, then Supreme Court should also say under 142 that henceforth contractual matters one should not approach High Court. Let us be very clear about it, my lord. End of the day, my lord, Article 14's relevance would lose. Here is a simple case. The prescription in the tender condition is, as far as bonus is concerned, the rate must be at par. Now, if it is not at par, consequences will follow. It's not a very big deal, my lord. Now, Railway's understanding, Railway Council's understanding of the Supreme Court decision, because they have understood in a particular way, what is the requirement that should due deference should be given to that understanding when it is patently wrong and patently arbitrary? What prevented you from saying, like in the other three tenders of your same Indian Railway? Therefore, my lord, to obviate all these things, that's the requirement is transparency. And how transparency can be assured? By clearly spelling out the conditions of acceptance of tender and following it scrupulously. As admittedly, my lord, it has not been done. My lord, my humble understanding is 12, 13 and 14, if we read it together harmoniously, my lord, what follows is that it has to be at par. Otherwise, my lord, what was the sense in making these bold letters? Be there quote at par against item so and so, quoting so and so. So it should be at par. Well, it's not that we are on a slippery ground, my lord. I think we have been able to, in our humble understanding, to make out a case of violation of Article 14, my lord. And that is an area a constitutional court has to look into it. Otherwise, my lord, and my learned friend was making an argument on prejudice. My lord, there is no requirement of pleading prejudice when you plead violation of Article 14. Antulle's case, Supreme Court has clearly said, my lord, and neither you can waive it, my lord. Even if a citizen wants to waive it, court will not permit that. Court will have to go into the validity of the actions tested on the touchstone of Article 14. Therefore, it's a very simple case, Miller. Question is, if it is not at par, what would be the consequence? Railway's understanding that higher is not prohibited, only lower is prohibited. That means you are keeping some leg room for you. And this is not what is normally understood as latitude in settling contracts. Those are in a different context. So, end of the day, nowadays everything, there is a stiff competition. Be it getting a job, be it getting a contract. So therefore, the best way to resolve all this issue is come out cleanly with the conditions. Then there will be no room for all these things. That is my humble submission.
This is a contract for how long?
2 years.
2 years.
Yes. I think they have operated for about 1.5 months,
and started
3 months.
2 years contract. Okay.
Deeply obliged.
Very cool. Good for you. Oh. PK Chaudhary, Planet Senior Council Assistant Vice R. Rahul, R. Gautam, and H. Gupta, CGC for the Railways, and Ms. B. Talukdar, Learned Council for response number 4. Here for somebody? Hearing is concluded. Okay, we'll have to reserve this one.
Yes, madam. Deeply.
Thank you.